video is being shown to you under Section 107 of the Copyright Act of 1976. Allowance is made for fair use for purposes such as criticism, comment, news reporting, education, and research. Fair use is a use permitted by copyright statute that might otherwise be infringing. Hit the like button. Let's go. What's up? What's up? What's up? It's your girl Survivor Speaks, and I'm back with another live video. Thank you all for being so patient with me. I've been having these computer issues since last week. Unfortunately, the new computer doesn't want to work, so I had to go back to the old one. I do apologize. I've been working on this stuff all day, called myself testing out the system. Still didn't work. So here we are. Nonetheless, I thank you all for waiting. Thank you, for the people that are tuned in here. Please hit that like button so that we can get this video out into the algorithm. I would like to say thank you to Loa. She's always here when I need her. Her and Nightbot. If anybody is being messed with by Nightbot in the if anybody's being harassed by Nightbot, just let me know. Sometimes Nightbot he gets disrespectful sometimes because he doesn't like when people use a lot of emojis and stuff like that. I turned off that feature, and sometimes he still harasses people that use a lot of emojis or says the same phrases over and over again. He likes to mess with them. So I'm gonna see what Nightbot is gonna do today. He does come in. He's pretty valuable. Especially when you work with mods, and then if your mods have something else to do, like he is a perfect backup. But he's also a little. What word do I want to use for Nightbot? He's a harasser. That's the best I can say. And then he has a very smart mouth, which I did not program. I want y'all all to know right about now. I don't know if that's something that's within the program where he originates from. But when somebody's doing something wrong in the comments, or using words that you shouldn't be using, he will time you out, but he will also put up a nasty message first. So, and that's not something that's set up by me. That's Nightbot. I don't understand. His mouth is very snippy. So I don't want nobody out here arguing with a robot because he is a robot. But yeah, he's that's something that I could not program from him, and they already have it set up. But he's a little snippy with his comments sometimes. So hopefully Nightbot doesn't mess with anyone. He's been doing good for my last 2 lives, and so because I had to turn him off the live before that. He was a mess, just telling people off and all this other kind of stuff. And I'm like, wait a minute, like you can't do that, Nightbot. But Fightbot Lower, that's accurate. I'm so glad that you know about Nightbot from other places, because so that I'm telling the truth. Nightbot is a mess, but you don't get to program that part of him. That it comes with him, and he's just like, I'm like, who programmed him to say these things? But you can turn off certain features, like I did turn off the feature where he would harass you if you use emojis. All caps, he will just I don't know. He told somebody in one of my lives. I don't think she came back because I don't know if she thought it was me. It was Nightbot. It was Nightbot. Like, Nightbot. Nightbot said something to her about her username, but the emojis was a part of her username. But Nightbot didn't want to see it that way, and he said something nasty to one of the people that was watching my live. And yeah, she ain't been back since. I don't know. You guys in the bushes, if you're here, you can hit the like button. I won't know that it's you. But what does happen, if you watch me from the bushes, if someone gifts memberships, it doesn't make a difference whether or not you're in the live or not. They will give you a membership. And that's how, you find out who's here. Sometimes it's just something that nothing's set up. It's just something that happens. So yeah, I have quite a few people that have memberships that, I don't even know them. So I guess, they come and maybe they want to listen to see what type of platform it is. I'm not sure, but they have memberships. And I'm like, I don't know any of these people. I don't. So, yeah, anywho, so we are going to get into the rewind of Ronald Anthony Burgos Aviles, the moron. Yes, I called him a moron. YouTube, I hope you don't find fault with that, because your YouTube is so sensitive. They want to demonetize you for every little thing. And so but yeah, he's the moron that unalived his 18-month-old son and the child's mother, because he didn't tell the truth. He told this young lady a fib, and so she got pregnant, didn't know that he was married, or she found out and then he told her that they weren't together and all this other stuff. So she never asked him for anything. When the baby turned 18 months, she was in school trying to get her license to be an RN. And things just got pretty hectic for her. She was trying to take care of this young baby. She had another son. And she was using like her financial aid money that she didn't use for school, and they send it back to you for reimbursement. That's what she was using to care for her child. And so then she was, she just said, you know what, I'm going to go and, get child support, because I asked him to just help me, and being that he won't do it on his own. And she hadn't asked him in a while. She just filed for the child support. And that was when she filed for the child support, that was when she signed her death certificate, unfortunately. And so this guy, he's a real loser. But we're starting out now. The lead detective is back on this on the stand. And he's awesome. He's back on the stand. He's the young man that I'm going to write Judge Whitaker. I'm going to write Judge Whitaker and tell Judge Whitaker that she needs to put in a word for Fulton County to have all of their officers, prosecutors, detectives, all of the people that work there. I need them to. You can just watch this trial right here, right? They can watch this trial and tell, like Glanville, had people write 30-page research papers because they went on a trip and didn't show up to jury duty. Well, yeah, they need to write, something on there. So maybe we can get the lead prosecutor, Mr. Annalise. I'm very fond of Mr. Annalise because I've watched him on more than one trial. He's very thorough, professional. All of the above. So maybe we can just have, give her, nudge her and say, hey, nobody that works for Fulton County that we've been able to see virtually is doing the job correctly. They're not doing a thorough job. I don't understand how you're officer and you wrote reports and all the reports are missing, or you didn't write the report, or use somebody that just take notes that you recycle to use over the. This is all a crazy mess that we heard in the YSL trial, and I'm just saying a little bit of what's going on over there. It's so much wrong over there that it's something else. But what people need to look out for is that I don't know if this went over everybody's head or you didn't see it or not. If you didn't see that, So right now, you know, Fannie they messed this trial up here for the YSL trial is just, they lost. I don't care whether they took plea deals or whether you lost it, you failed. You failed at this RICO. And the RICO was the only thing that was helping them. So, but you failed for this RICO trial. So then now, of course, this failed. So the RICO case they got against Trump, y'all might as well just kiss that goodbye because that's not going to go anywhere. However, Miss Fannie Willis did a press conference and she said that they are going to have another, they have another RICO case that they're going to be charging, but this time, it's just not going to be Fulton County. It's going to be Fulton County and some of the surrounding areas, and it's a joint venture. I think she said it's like four different counties coming together. They got another RICO trial coming out, and if it's going to be anything like the mess of a RICO that they have going on now, I feel sorry for those people. I really, really do. But you know, we're gonna pray to 8-pound, 10-ounce baby Jesus. That because sometimes you gotta pray to the little baby Jesus and Jesus in the manger. So yeah, we're gonna pray and hope that the jurors, you know, really would have been paying attention to the evidence that's been shown to us. And the evidence does not show that the two men that's left on the trial for YSL, that they are guilty of the crimes that they're charging them with, the red rums that they're trying to put on them. From what we saw, from what we witnessed, those young men are not the two people that you're trying to now put the drinks red rum and nuts red rum on them. And that's only because everybody else was given a plea deal, and none of the plea deals that they took included those red rums. So now you want to take something now and put it on somebody else. Oh no, this person did it. Oh no, this person did it. No, this person did it. It's a mess. That's all I got to say about that. It's a mess. But without further ado, let's get into this video. Like I said, the lead detective is on the stand. Yeah, let's go. Let me get that up over there. Let me go here and tell them to not do that. And here.
Show you with the mark. That states to 5 with 5. And that's when you right next to it.
Lord, can you drop a 1 in the chat if you guys can hear, please?
Mr. Hernandez, are the bags inside of that bag labeled separately, or?
Yes, sir, we did that right now.
Okay.
Okay. So it'll be labeled over that right. All right. So this is State's Exhibit 5. I'll show you what the label as State's Exhibit 5.1. Can you look at that?
Yes.
Okay. You recognize that?
Yes.
Okay. You can take 5.2.
Thank you, Loa.
You recognize that?
Yes, I do.
5.3.
Yes, I do.
5.4.
Yes.
5.5.
Yes.
5.6.
Yes.
And 5.7.
Yes.
And what do all these items have in common?
They're strands of hair. They're the rock with blood.
They're the rock with blood.
They were found in the crime scene.
So this is Exhibit 5, that we labeled it 5.1 to 5.7. Thank you. move to introduce. Offer. Right? States Exhibit 5, which contains 5.1 to 5.7.
Any objection? Admitted.
I'm going to show you the markers 5.7. You remember seeing this item?
Yes.
And what is it?
It's the rock that was found near Grizelda near the left white shoe.
And what is on this object? This rock?
Blood.
Now, when you went back the next day, how many samples of hair were found?
Yeah, we collected them also. So
Well, I'll ask you how many evidence bags contain hair that
yeah, it's 1, 2, 3, 4, 5, 6.
And when we say hair, what type of hair?
It's a human hair, long human hair.
When we say long human hair, what does that mean? Gender?
I don't know specifically gender, but it's long.
Did Griselda have long hair?
Yes, she did.
Is this hair consistent with her hair?
Yes.
And where was hair found?
Again, they were found where Griselda was found and where Dominic was found.
Do you know if you all tried to do DNA on this hair?
Not those hairs.
Do you know why not?
Because there were several sharp force injuries on the top of her, by her head area, and we knew that it was just hair that was cut off by during the attack.
So your testimony is that the hair that was found along the trail was hair that was cut during the attack.
Yes.
And no further questions.
We can put any redraw.
Just a couple of questions.
Sure. Go ahead.
Detective Castillo, as the lead detective, you review the reports, the incident reports, and supplement reports prepared by other investigators who are assisting you in the investigation, correct?
Correct. There are many of them. So
So you had occasion to review the interview that was conducted by investigator Elizondo and by investigator Reyes of Mr. Burgos Aviles on April 9, 2018.
yes.
During the course of that interview, Mr. Burgos advised by both the detectives Reyes and Elizondo that he had picked up the phones, the cell phones of the victim because he knows that they contain valuable evidence and that he put them in his control unit to preserve them. Do you recall him telling them that?
During the interview, no. I recall him saying that he saw cell phones, but he never said that he recovered them and put them in the unit.
Did he tell that to you or to another investigator?
To another investigator during that interview.
Do you recall who the other investigator was?
I believe it was investigator Ernesto Elizondo.
Okay. So, just to clarify your testimony, Mr. Burgos told the investigator and Elizondo on both of his two cell phones and recognized that they're important evidence in the case, so I questioned my patrol unit.
No, he
Or words for that.
he didn't say that. No, he said that he saw two phones there, and I think I believe that the questioning continued. And you got to realize that we really didn't know about the phones while he was being interviewed. So I would say that the phones weren't important at that point. We were looking for phones because
further questions. So, anything else? No, we're on. Detective Garcia, you can step down. You are ready, so you may go back to business. Thank you.
Thank you. All right, this time, the state of Texas will rest.
Very well. Approach, please. We're trying to decide what kind of, the state has rested their case. And there are things that we have to do if and when, first, if the defense will decide to put on any evidence. As you know, the defense has no burden whatsoever in this case. And therefore, it is absolutely their right and privilege to put on anything that they like. And of course, the fact that they do or they do not will not factor into their deliberations as you know. So I think rather than have you sit there for like some time, I'm going to release you to come back until 1 o'clock. That way you can go and maybe even have lunch at home. Who knows? In any event, you all decide. I do need you all back here at 1 o'clock. the case, even though the state has rested, the case is still not given to you yet. You remember that it's not given to you yet until all of the evidence is in. We still don't know if all the evidence is in. 1, 2, until I've read the instructions and the charge to you, which I have not done. And 3, until counsel has given you your final arguments. So there's still a lot to do. All right? So we'll see you here on Monday. Thank you.
You guys adjourn?
Please have a seat. Thank you. Okay. The jury is now out of the courtroom. There is a motion that was filed by the defense, which I'd like to hear now.
Yes, Judge. Ms. Gazelle is going to argue the motion. It's a motion to strike Dr. Stern's testimony as false and misleading.
All right, come on. I'd rather do it, unless you need your laptop with you for this, I'd rather do it up here than do it across the courtroom. Thank you. Counsel for the state, wherever. Thank you. You may proceed.
Thank you, Your Honor. We will try to read the same motion to oh, and I actually have a part of the motion for you if you have. Sure. Okay.
Yeah.
Okay, so to confirm the court now has before the motion to grant the full testimony of conduct within their concern.
Correct.
Well, and we have proposed several remedies. One of them would be to strike the testimony entirely, or we've also asked for curative instructions on this part.
Right.
We have gone back and reviewed the testimony that came in for Dr. Stern on Monday, June 6th. She testified that she, on direct examination, she testified she passed her boards in 2001. However, she is not board certified. On cross-examination, she was asked what she was referring to by that. She said, my medical pathology board, and she was asked on what date she was certified. She said 2001. She's not board certified.
So in her cross, you're saying she said that she had passed her medical pathology boards?
Correct. And then she.
Do you have the testimony to that effect?
Well, Your Honor, we have an unofficial transcript. If there's a dispute about it, we are happy to defer to the official transcript by Ms. Lentz.
So what is the unofficial? Where did you get the unofficial transcript from?
Your Honor, as you're aware, this trial has been televised and put up in its entirety on the internet, so we rewatched it to make sure you're correctly represented with what we
So,
said.
thanks for when, and tell me what you believe she said under, using your unofficial transcript.
Yes, Your Honor, which has been filed with the court as exhibit A on page 21 of that document. According to our transcription, Mr. King said, Doctor, you mentioned that you passed your boards. What exactly were you referring to? And she said the American Academy of Forensic, the American Academy of the American Board of Pathology, my forensic medicine boards given by the American Board of Pathology. Mr. Pena, I see. So what date did you get certified? Stern. It was in 2001. And so our position is that Dr. Stern has at least created the misleading impression that she's a board certified pathologist, which she is not. Mr. Alaniz called her and we had a conversation with her yesterday morning in which she clarified at that point that she only passed her board. She has not been officially certified. However, she is a certified doctor of osteopathy. We recognize that. But since Dr. Stern is introduced as the state's only expert witness on the actual nature of the wound at issue, and it's been a major part of their case, there were 3 different medical professionals who saw Dominic at the time the interview within 24 hours and all reached the same opinion. Dr. Stern is the only medical expert to reach a contrary opinion, and the state introduced that testimony through.
So the board, all medical doctors have to pass a board, right? Am I saying that correctly? I don't know. I don't know that. Perhaps we should have a doctor here to that effect. But I believe that sort of like a lawyer passes the bar, right?
Yes, exactly.
I think that's a way of explaining it. So assuming that that's correct, I hope that whoever's listening to this doesn't think that we are whatever for thinking that. But in any event, when she said I passed the boards, she was being truthful. Your concern is that when she, at cross, when she said, I think you have the language that you alleged she said, which is when she was asked which boards did you pass, and she went through a litany of, was it a laundry list of things, or was it just an attempt to describe it?
Your Honor, my interpretation was that it was an attempt to describe. I can read it back
Please.
Because I don't believe any of those assertions were complete. Again, Dr. Stern responded to the American Academy of Forensic, the American Academy of the American Board of Pathology.
So she said the American Board of Pathology.
Correct. My forensic medicine board is given by the American Board of Pathology. And I'm aware that Your Honor has before you Exhibit B to the pending motion, which is official letter from the American Board of Pathology certifying that Dr. Stern has not been certified by the board. And we believe this is yet another issue going to her credibility. And she has been certified as a doctor, but not as a certified pathologist. I know many doctors that I would not like performing autopsy and identifying wounds, even though they have been generally certified as a medical practitioner. And again, this is allegedly her opinion testimony is kind of the missing link to this part of the state's theory, and it goes against the lead of the other licensed medical professionals.
Right.
We believe this created at least a false impression, and the state has both a duty to correct it, and it would be a constitutional violation for the alleged Yes, Your Honor, we would ask first that the testimony of Dr. Stern be struck in its entirety. We, in the alternative, would ask that this court issue an instruction informing the jury something to the effect of that according to the American Board of Pathology, Dr. Stern has not and is not board certified, has not been and is not board certified. That this court issue a further instruction that Dr. Stern's testimony to the contrary should be considered in relation to her testimony as a whole, and three, that this court instruct the jury that it may reject the entirety of Dr. Stern's testimony and conclusions on the basis of her lack of tenure.
Did you say and in the conjunctive or the disjunctive 2 and 3?
We would defer to Your Honor, but our position, I believe, is clear that we believe the testimony should be stricken in its entirety and at best limited by this court.
Okay, thank you. Mr. Alanis.
Yes, Your Honor. I was informed about this situation yesterday morning. We did, like Council Rosell stated, we did call Dr. Stern. I wanted to try to clarify this. Dr. Stern was clear in explaining that she never said she was board certified or a specialist. She said I passed my boards. I don't consider the transcript that Council is presenting to the board to be an official transcript. And also, this is compiled from YouTube and other social media or other internet sites showing the trial. So I would not agree with the transcript, but it is clear that Dr. Stern did say that she passed her forensic boards in 2001, and she's a member of the National Association of Medical Examiners and the American Academy of Forensic Sciences. That's what she said. It's a far cry from what counsel is alleging that she would have come up here and intentionally misrepresented or giving some sort of false impression to the jury. To the jury, where they're making reference to the questioning by Attorney Peña. That says you mentioned that you passed your boards. What exactly were you referring to?
You're reading from where?
I'm reading from what she said.
Okay.
It says the American Academy of Forensics, the American Academy of American Board of Pathology, my forensic medicine boards given by the American Board of Pathology. That's
What do you mean by that?
whatever it means. She's
Board of Pathology.
Yeah, that she's passed her boards, her tests, like we passed our bar exam. Or
The only thing is I don't think is I know that when, and again, I should say I know,
well,
right?
the thing is this, Your Honor, I really think this is a play on words. Because then Mr. Peña says, I see, so what date did you get certified? Well, it was in 2001, she says. And he says, now I'd like to talk a little bit about your history. You spent about the last 16 years as a medical examiner for County, correct? And then, that's correct. And then, all right, let's talk about your work as a medical examiner in Alabama. So that's when they went into the Alabama history. So, my concern is this, Your Honor. The jury is the judge of the credibility of the witnesses. What they hear and what weight they give to our experts is up to them, whether they believe all, some, or none of their testimony. Really, what the best remedy for this is what this would be argument, a closing argument. We never presented her as a specialist, a board certified specialist. The record's clear that Dr. Stern was honest in her responses. The one that injects the word certified into the questions is Mr. Peña. But then again, it's that word certified is so broad. If he would have said, "Are you a certified specialist?"
Let's put the word certified out of the equation for a little bit and just concentrate on whether or not she passed her board of pathology.
Okay.
Did she say that she had passed her board in pathology?
Yes, she did. She passed her boards.
Well, but in pathology? Because everybody has to get a specialization, right? I mean, I don't know how this works, and perhaps we need clarification on that. How does that, in other words, can you all agree, look it up, to see if y'all can agree on with regard to how a medical doctor actually gets, they go to medical school, they go through all the rigors of that, they do their residency, whatever it is that they do with regard to that, which is very rigorous as well. I have several friends that have gone through that. We both end up in school, graduate school at the same time, and I finished, and they did not, so they stayed behind and finished their work. And then after that, they I guess they present their boards, and they take a test, and they pass, or they don't pass the test, and if they don't pass, they have to do it again. And so that board is what? Is that the board of just medical, whatever it is that you're doing, or what is it that it is as far as you know for sure?
As far as, no, all I can say is that the proper remedy in this situation already left the station. The time to have done that was under cross-examination to go in depth as to her. If there was a question regarding her licensing, her boards, her certifications, whatever it was, that's what cross-examination is for. Now that they're asking the court to do their job and saying, hey, strike her testimony because we didn't like what we heard.
But then now we can bring her back.
Well, they could call her back and she could clarify this, but she never got up here and misrepresented anything. She said, I passed my boards. And then
I want to know, did she pass her American Board of Pathology? Because she said American Board of Pathology. Or at least that's what the transcript that you read said. Yes.
So I think part of the issue here is that our understanding from, and again, this is off the record, this was what Mr. Allen's name, Dr. Stern, Mr. Rose. She represented to us, again, we are not familiar with the licensing process, but that there is an exam, and that is a part, but not the complete certification process. So she was never certified. She asserted that she never testified she was certified, and to the extent that the word certified was introduced and offered by Mr. Pena, she did not clarify, no, I am not certified, I passed my course in 2001. That would have been the opportunity. Surely we can't impeach her with this document because it's not a statement of hers. We gave her the opportunity on cross-examination to clarify the record as she insisted that she has, and it was not done. And I would
So
also,
when was she, so, okay, certified is one thing and then licensed is another thing, right? Or is it the same thing? No, when did you become a medical doctor? You have that?
We can further clarify this with a full transparency statement. They have her CV, which I have her
Okay,
CV
good.
here, and the court can examine.
And that's part of their exhibit, right?
Well, it's what they have that as far as her background.
Okay, so she's licensed 2000, Hawaii, 1996. So
Mhm.
she, well, she did say American Board of Pathology, Forensic Pathology Examination 2001. She did say that.
Mm-hmm.
It says passports.
The difference. Well, all she says is that I don't know what question you all asked her. Asked the American Board of Pathology, but it says here that Dr. Winstern is not a diplomat of the American Board of Pathology. So I don't know what it is that it.
and has not been certified by this court.
Right, but well, they didn't ask her have you been certified by the American Board of Pathology. They just said have you been certified? Are you certified?
Yeah, and that can be any certification.
So I'm not sure. Right. Yeah.
If you look and we can mark this as an exhibit on voting. If you notice under board examinations and certifications,
Yeah.
when you're certified, you're a diplomat. And look what she says on board examinations and certifications. Under the National Board of Osteopathic,
Oh, she's a diplomat.
she's a diplomat. And then look what she says on the American Board of Pathology
Examination.
examination. There's no misrepresentations here, Your Honor. It's all there.
Okay, so she puts on her CV that she's. I guess the distinction she makes between the National Board of Osteopathic Medical Examiners, which also is a medical examiner license. I'm not sure what osteopathic means, but that she's a diplomat there since 1996. And on the American Board of Pathology, she classified it as forensic pathology examination 2001. And that CV is not, it is a part of the exhibit.
We did not include it.
Okay.
We'd like to submit it.
As part of this, for this hearing.
Judge, do you want it to be under state's on jury?
I guess whatever you'd like, it's for purpose of this particular hearing, and they've attached their exhibits to their motion.
We would say if it's going to be made an argument before the jury, then we would want it to be made a trial decision.
That was,
Even in our closing, I would not, my intention is not to go up there, Congress specialist, or that she's board certified. I wasn't even use those words in my closing. She's a medical examiner, and that was her opinion. What they have on their side is they have the ER, they have Dr. Rodriguez, and then they have the other clinic saying it was an insect bite. You know, it's what the jury decides to be.
what was the remedy that your remedy is just leave it the way it is, basically. Okay.
We would.
Aside from number one.
Lower.
Instruction from this court instructing the jury that she is not board certified by the American Board of Pathology. That her.
Well, see, I don't know if I could say that other than saying that she's not a diplomat of the American Board of Pathology.
But Your Honor, we would also stipulate to
Because that's not
admission of the exact language from that letter. So the full sentence of the board being that she is not a diplomat and has not been certified by this court, going to a jury as an instruction relating to Dr. Stern's credibility as a whole and her opinion.
Sort of like run through that. Okay, number two was basically an instruction saying that Dr. Stern.
Perhaps according to the American Board of Pathology, Dr. Stern is not a diplomat and has not been certified by the board.
See, the thing is this: it's very difficult unless you all agree to the instruction to allow the instruction in, because it'll be an evidentiary instruction of some sort without having evidence actually in. And so I hate for it to be a comment one way or another on the weight of any part of the evidence. So as much as I hate it, they just Mr. Alanis, as much as I hate it, we have to, if y'all could find the words to perhaps agree on in terms of that, that as opposed to an instruction on what Dr. Stern is not a certified diplomat of the American Board of Pathology, I think she would probably testify that if she came to testify, she would testify that she is not a diplomat of the American Board of Pathology. That would be an easy stipulation to make, and so that would then be able to be used by defense at argument. In fact, she is not matter of the American Board of Pathology, and therefore, and that she may have said this or that with regard to that particular question. Because that particular question in its entirety was not asked. It was asked sort of like in pieces after the response was. And I don't know if are you certified? If it should have been, are you certified via the American Board of Pathology as opposed to are you certified?
Well, yes, sir, in context, immediately following her response that she after her divorce of the American Board of Pathology and was asked when she was certified, she gave the date that she got the certification. I believe that that was her opportunity to clarify and she didn't
She just asked the question. I get it. Okay, so that's what I'm because you're saying that I should instruct them that she's not, and then you're saying I should also instruct them what?
that her representation of the failure to clarify goes to her credibility and trying to consider it.
Okay, and so on your end, Mr. Anthony, you're saying I don't think you need any instruction. I think the jury should be left the way it is, and we'll take it from there. I strongly should agree that you all should because other than that stipulation, it would have to be her to be brought back, and then you have to ask her those questions.
Well, Your Honor, yesterday, I wouldn't be discussing this when it comes to Ms. Jones, if potentially indicated stipulate to the initial letter to the jury, we would also take that as a remedy if the district court agreed.
Well, my official position is this.
You can get this in, and you would have no objection to the CV in if he does that, or Mr. Peña, Mr. Bond.
That'd be the only way that we would see.
One of the you, her CV in this letter.
As long as, I would also ask for a stipulation so that we could read her testimony during arguments on channels and official transcripts.
But if you ask for it, there could be an argument. Probably. It'll just take a little bit to get it out, but an argument. I'm not even looking at my court reporter right now.
Very fond of Ms. Lutz, and I've bothered her a lot of these years, so
We would look for it, and then we'd see, and I say we, as we're a team, and we would try our best to be able to get that out. I mean, this is not there's no daily here, so as a result of that, it's different.
So, Your Honor, we at the end of this, one of these arguments that are being made, the state does not agree to having. We respectfully object to.
I thought you said you agreed.
We object to the court comments on instructing the jury on the testimony of Dr. Stern. That is the purview. That is the area of the jury.
Oh, that's exactly what I want to avoid. I want to avoid that. So to avoid that, I think that you get your CV in, you get the American Board of Pathology letter in, and then you all will give it up to argument after that.
I think right now, the request was made that her transcript be read in whatever way defense counsel wants to read it.
But that was in conjunction with this.
Well, correct. The problem is, though, is now it needs to be taken out of context.
That's your job to argue for or against.
But the thing is, it's being taken out of
I'm not even sure it should be your job, actually. It's going to be Mr. Alexander's job.
Yes, it will be. And the thing is, now it's going to be taken out of context without the witness on the stand to defend himself as to the clarification of what exactly it was that she meant by that testimony.
It is what it is. I mean, it is what it is.
Your Honor, do you give us an opportunity to?
I mean, you can very easily clarify the way Mr. Alexander did now. She didn't say she was a diplomat. She said she was under examination of it. In fact, she wasn't asked whether she was a diplomat. She asked whether she was certified. All right. That's my hard inclination. So
What's your hard intention?
to allow both documents in as evidence, if you all would so be inclined, and to allow that in, I think it would then be.
Your Honor, the other alternative I would ask the court to consider is having Dr. Stern be testified on the phone. We can get on the phone. He can be thoroughly examined on these questions. And that way, the jury is able to hear from the doctor himself, which I don't think will take 5 minutes, 10 minutes.
That would be over our objection with the court. She testified in person, and we believe that the
Where is she?
Well, she was released. We got to track her down.
Well, you tracked her down last night, right? Where was she last
I called
night?
her yesterday in the morning when I was advised.
Where was she
She's
yesterday?
out of town. But I can find out if she's in town. I can find out if she's here.
No, she's not. She's not okay.
So in any event, that would not be the most efficient way of doing things, but quite frankly, I think you all should take a look at that. Because their request is also not being, in other words, I'm not striking her testimony. I'm not instructing the jury with regard to the weight that they should give this evidence. Basically just saying this has to be considered, and you all give it whatever consideration you want to give it. And you all could basically argue what her words were in consideration to what the facts are.
At a minimum, Judge, that's what we would ask. I believe that if that is the court's ruling, it would be a objection because it is not enough to cure it based on the testimony that's had. And I can foresee a circumstance where there was a confusion, and I got a sentence that habeas lawyers will go back and interview these.
No question.
If they believe that Dr. Stern was a board certified pathologist, and based on everything that's happened so far, I believe they would say yes, and it's only the court's instruction. I say that very much fantasizing.
Or she could just be cross-examined.
Telephonically, Judge, I do not-
No, but you have to be by video the way your expert came in.
Mm-hmm. Look, they don't want that to
Yes,
happen. Look at them when he said that she can testify on Zoom
But that,
because she can do that
it
from
is
her
my
phone.
suggestion, but I was hoping that both of you would accept the suggestion as opposed to having Mr. Boggs under, despite the fact that I think it was his idea to begin with, come up and say it'll still be over our objection. I guess he wants to create that sort of possibility.
Well, we can meet with them and see if we can see.
All right. All right, let's do that. And then right after that, you're going to head out to the jail to consult with. Can we take him down there already, or do you need him here for some reason?
I believe you can go to just start consulting until
So the time, I will not start the clock until you leave. Do you want to go to the tunnel, or I'm just kidding. Until you leave the, you're gonna be like my kids, you know. It's like, don't start the clock yet until I actually start the game, and then my 15 minutes are up then. So you walk fast. I'll start counting after y'all leave the offices. The jury's not going back to 1. So anyways, you may not be able to eat today. So take it from there. Thank you. So get back to me here in 10 minutes or so. Please confirm. I'm just going to tell them again. Okay, bye. Okay, good.
All right. I think there are going to be a recess of some sort. Let me just see if I can go right past here. That is the good thing. While I'm finding the spot, I just wanted to finding the spot. I'm wondering, like, what people's thought, or what are people's thoughts about Diddy possibly being released on Monday? Possibly. I don't like it, but okay. I'm against it.
Well, I see him there sitting with you. Thank you. So in any event, okay. So Mr. Pena, Mr. Boggs, Jose, Sean, and all counsel are here for the defense. Sean, these are things here. What's defendant's present? Go ahead.
Your Honor, so we put back and forth on this issue. Ultimately, withdrew the agreement of submission of both documents, and we were able to contact Dr. Stern, who's writing in from out of town. She can be present by 2:30 p.m.
At what time?
She can be available to testify at 2:30 p.m. to clarify this issue. We looked into we spoke to our appellate counsel because it's a credibility question that belongs to the jury. He suggests that it be testimonial and that she be cross-examined on this issue. We have no problem with that. And based on the counsel, we're in agreement with the question at 2:30.
Very good.
Is that okay with the
That's good with me. Thank you. I prefer that as well.
yes, Judge, I think District Attorney has been correctly that we believe we have a agreement, but the District Attorney, the jury had agreement.
Not just his plane. This is so much. He's a billionaire.
If there is a question about impeachment, we were able to have the District Attorney stipulate to a letter that we had presented to them in its original form.
Well, I mean,
If it's necessary.
And he's still committing crimes while he's
the question is, are you going to
incarcerated.
be able to use the letter when you cross-examine her? And if it's for impeachment purposes, the rules are going to apply. Whatever the rules are, I'm not going to make it. If you want to make a ruling right now, I will. But if it's going to be used for impeachment purposes, and basically that's, first of all, you're going to go through a clarification period, and depending on what she says, then this becomes relevant or not relevant, depending on how she testifies. So if she testifies, here I am, then okay. Because it wasn't, she actually did not officially say she was, mean, there was confusion and required clarification. And again, I don't have the official. I'm going with what Ms. Bozell showed us, but I do have Cindy going over that. So because we're going to have her here, and you have an opportunity to call her if you'd like, then
No,
that's
but you
right.
just doing.
All right.
I would say, for the record, of course, the CB that's provided by the attorney for Dr. Stern under the category
Of course. Of course.
pathology examination.
He's where he should be, and that's just what it
Whether
is.
she technically very lawyerly on the stand, sort of mumbled through some words, maybe different from what the records that she files as her privilege.
I feel bad that he's using his kids
Clarify the mumbling if you want to call it that. Take it from there. But you'll have an opportunity to do that.
to garner sympathy from
Then so it is. So you're
the
I guess
public.
it's 11:25, 11:22, 11:20 actually. I'm going by the Google clock over here, but we're going to this 11:20. It's a regular witness that they bring, and therefore you're allowed to cross them or whatever the rules say. Cross them. All right. Thank you. So now we just need to make sure our hallway is cleared for Mr. Burgos to go in, and then you all will follow, and then of course whatever time we have left after that is your sandwich or hamburger time, whatever you're gonna have. Salad. Okay. Salad. Thank you. We'll see you at 1 o'clock. Thank you all.
Let me go over here and move this up. So she's going to come back and testify, and they're not going to win that argument. I mean, it's just ridiculous. It's offensive and everything else. Like for you to just try to trash somebody's profession that, like sometimes the defense attorneys, are so, they don't care what they're doing. Like they only care about winning. Some attorneys, they only care about winning, and a lot of times it's defense attorneys. Like for the YSL trial, I can say none of those attorneys were trying to do anything like underhanded or sneaky, because they didn't have to, because the state, with all their shenanigans.
Check your phones. Make sure it's on silent, and we get started. So I think that Ms. Lenz just handed you all, I think maybe the relevant portions of that section of the testimony.
Of course.
So it's just in case y'all are going to need that. In any event, okay. So just to summarize, how we ended this morning was that we were going to. The state is rested. There was a motion filed by the defense with regard to requesting the court to urge and urging the court to in fact strike the testimony's entirety of one of the state's witnesses, Dr. Stern, alternatively striking a portion of it and giving further instructions. So the court then heard from both counsel and decided to, if the motion continued to be urged, I'm not sure it did, I think it did, it was, then I would overrule the motion to strike her testimony or to give instruction, and alternatively would allow as well. So in any event, that is where we're at. And of course, she's not here until 2:30, I believe, because she was coming from out of town. And so then our next thing that we have is in a minute when I bring the jury in, then I'll and I'd like to be able to know now, after you've had an opportunity to speak to your client, what is it that you all, what witness are you going to call other than Dr. Stern? Can you get closer to the mic, please? But you can come up here if you'd like, either way. Then I know you like to stand when you talk. Make sure that's make sure that one. That's why I asked him. Okay. Oh, so she's literally driving over here. So then let's do that. Let's
Oh, that's why.
I think there are two small matters you'd like to discuss with your honor.
okay. So then let's. And you want to wait until after we're done?
I think we can confirm.
Okay. So I have a copy of the charge on my screen, and again, we're anticipating that we're going to be one witness called by the defense.
Is it back now, Laura?
If there's something in the charge that in fact will require that witness to testify before we make a decision, then we'll wait on that. But other than that, we can do it now. And you all are in agreement to do that. Is that correct?
Yes, sir.
I'm sorry.
Yes, sir.
All right, thank you.
All right, thank you. I don't know
So
what.
we have a proposed charge that's been filed by the state. Has it been filed? Or, I know it's been handed to me.
I know it's been handed, Judge. I don't think it's been.
Okay, so it's been handed to both. I'm going to work with the copy that I have. In fact, let me see if I just print out this one.
Judge, just for the record, because
I have a red line copy. Y'all have. Let's see. I don't know why I got that.
That's the copy that we're working from. It indicates the changes on both sides of the matter.
Okay, so I would like to print this out without all the red line stuff that is in there. So if somebody can do that for us, please, and we'll take from there, just so that I can file the copy we're working off of, and then I'll get a final one after we're done. You can, if you have it on you can email it over here to Alma Martinez. But one that's not, I know there's probably just a couple of buttons that we got to push to be able to not to maybe just a view button. Okay, so I'm going to work with what I have here, assuming that this is in fact the one that we're going to print out. I think it is. So I'll file that copy, and then whatever changes are made to it, we'll make them on the record, and then we'll, again, my ruling changes are made, we'll refile obviously that one before we read through. Go ahead.
Yes, Judge, I believe that the first part, I don't believe we discussed this, but it does say the defendant, Ronald Anthony Burgos Aviles, stands charged by indictment with the offense of capital murder, but since there's 2 counts, if we can
Can you
just,
put a copy on the so that we thank you. And then we can point up the area you're talking about.
so as far as this area, we just see that out that it is 2 offenses. So, here would be by indictment with 2 offenses of capital murder because there is 2 counts. I'm not sure that would be an argument to make.
So where's that at?
It's the first paragraph of page 1,
Oh,
right here, Judge.
it's because
Would be 2 offenses of. I'm just trying to figure it.
so there's 2 counts.
Yes, Judge, there's 2 counts.
So okay, was that something you all did not agree?
No, Judge, that's just something that we noted right now whenever we,
Okay,
It wasn't raised.
it was not raised.
I mean, in our position, it's 2 counts of the same offense. I think they clearly donated it later. But
Mhm.
and then it would, I believe on page 2, paragraph 3.
So now you're going to whatever you all are.
Yes, Judge, this would be the.
So paragraph 3 of page what?
Page 2.
All right.
So in this paragraph, we wanted to reference language which says that they can consider all relevant evidence pertaining to the relationship that existed between the deceased and the defendant. I know that the legislature does have some precursor language as far as the Texas Code of Criminal
Okay,
Procedure.
just so we know,
Yes.
this is your proposed charge, and you want to add language to your proposed charge?
No, Judge, it's already on there. That was our proposed charge to keep it. I believe that they're arguing for us to remove that section.
Do you want to remove
we would like to remove Roman 3, Your Honor.
We would like to
all
keep.
3?
Yes.
And you want to add the word relevant?
Yes, Judge. Just so that it
You want to
can.
keep 3 and add the word relevant?
Yes, Judge. Just so that it can hold the statute clarity.
Okay, go ahead and tell me why.
Yes, Your
No, not you, her.
Well, Your Honor, that is language proposed by the state. We were unable to find it in any pattern jury instructions, and our position is it's duplicative of the first sentence of Roman 9 and highlights the state's theory rather than introduces any evidentiary principle or element of the crime which the state is required to prove, which instructs the jury that they may consider all of the evidence, which, necessarily encompasses any evidence the state has introduced as to the nature of the relationship.
If you tell me where Roman, I don't have Roman numeral 9 paragraph.
Your Honor, it is on page, for my draft, 8, I apologize, Your Honor. It's page 4 on my, Roman 8, my mistake. You may consider all of the facts that are shown by the evidence and draw natural and reasonable inferences from such facts. We believe that encompasses the specific evidence to which the state is highlighting in paragraph 3.
And so she says it doesn't exist. I don't seen it before.
Yes, Judge, I've seen it. We have it in our jury charge or our pattern jury charges, but that language we included in every case, the one that she's citing to.
Other than you including the case.
Well, not those. I'm saying like the other language we always cite as far as all the evidence, but since this is a homicide, it does change and the law does give us. Yes. So the Texas Code of Criminal Procedure, section 38.36, gives this exact language. In all prosecutions for murder, the state or the defendant shall be permitted to offer testimony.
3836?
Yes, Judge.
One second. $38.36 AB.
It's A, Judge.
Okay. So clearly, for purposes of bringing the evidence into the trial, you use the statute to argue it's relevant because the statute allows us to bring it in because all relevant facts and circumstances surrounding the killing and the previous existing all relevant facts and circumstances going to show the condition of the mind of the accused, time of the offense. That gives you then opportunity to, I can bring this in, I can bring that in, because it goes to the actual statute. And I guess what you're saying, as well, what you're saying is that if you look at the pattern jury charges, that's not one of the optional or alternative paragraphs that you see there.
That's correct, Your Honor, and furthermore, our position is that that evidence was, as Your Honor indicates, introduced in the state case in chief. It's covered under the first sentence of Roman 8, which instructs the jury that they consider all of the evidence which has been put before them, and to highlight that specific evidence would be highlighting the state's theory of the case and theory of the improper.
So I see what your concern is. In other words, if you highlight that particular instruction, it's in fact highlighting the evidence that the state has been wanting or has been introducing and want the jury to focus on, which is the relationship of the parties and the fact that circumstances and the condition of the mind of the accused at the time of the offense. And so, what the concern then would be, what I hear them saying is, am I commenting or on the weight of the evidence merely by instructing them that they can consider it? Is what my concern is, but is what they're, I think, saying in a different way.
Yes, Your Honor, that the instruction would in effect be directing them to particular portions of the state's case in chief to consider, in addition to being told to consider all of the other evidence that was introduced, which encompasses that specific section.
What you're saying in paragraph 8 starts with, you may consider all of the facts that are shown with the evidence.
Yes, Your Honor.
And all of the facts mean everything that came in.
Yes, including the specific portion testimony.
And Judge, for us, it would be that the statute allows them to consider more than, to consider the relationship where it wouldn't allow them to consider the
Well,
relationship.
that's not what the statute says. The statute doesn't say the jury may consider. The statute says the defendant shall be permitted to offer testimony. So this talks more about what you're allowed to offer as opposed to what the jury should be allowed to consider. The jury should be allowed to consider all the evidence that was brought into the trial, period, and put whatever weight they want on the particular case. And you know, I'm telling you, we put this provision in there many times. So I don't think anybody's ever brought it back to our attention. The problem with this case is that it's that case, and you're gonna have so many eyes looking at this case, and so many people reviewing it, and they're gonna hinge and on every single word that we've said so far, everything that was said in the letter, anyone said in any part of this trial, and would just be adding an additional point, and I think that's what I'm concerned about. Clearly, you're able to bring it in. Okay. Unless y'all show me something that says that it's been looked at and trampled on and reviewed by the Court of Appeals before, or in our Court of Appeals here, I suggest that we just leave it out.
Okay, so Judge, we do have, okay, yes, Judge, we do have the jury chart, I'm sorry, the jury panel chart here, like, just.
Go ahead.
And this is for the capital murder, my representing considering your verdict.
Yeah, paragraph 4 of that particular.
So it says capital murder, it's
Yeah.
a capital murder, and then the language is
All right. And is that the battery charge that you're showing me? Can I
yes,
just-
Judge, it's a Texas state.
All right, thank you. Okay, so I said, unless you showed me, you showed me, and your request, then you do that. Let's move on to the next one.
I believe there's only one other matter that we want to raise. It's my understanding, let's see, that we do not this addition necessary, but one of your owner's opinion on it, which is in the instructions as to the count 1 and 2, in the second paragraph of each on page 3 under 1 and 6, we would request that your honor instruct the jury that unless you so unanimously find beyond reasonable doubt, the instructions as proposed to us did not include the requirement of a unanimous verdict. We believe that's required by law.
I think she added it.
Judge, it's on there, I just never seen it, I just wanted to get, your honor's
Oh, she
response
added
to
it.
it.
And it's your proposed charge.
No, Judge, that's not our proposed charge, those were some of the changes, we just highlighted that part, this is already a merged version of both.
Hold on. You didn't add it?
I believe that one's already a merged version of both defense and state's arguments as
So
to,
you don't want that?
we're just looking for
Okay.
maybe some instructions on that.
All right, let's look. Okay, can I look at the paragraph right before that? Oh, let's see. Here we go. So it's the application paragraph, basically. It is what it is, right? I mean,
Yes, Judge, I mean, I just wanted some guidance. Oh, sorry.
They do have to unanimously find out beyond reasonable doubt. Right? I'm fine with that. I'll just see the unanimously in there. Okay. All right, we'll leave the word. Did you want it in there?
We did, we added it in here.
Okay, so we'll just leave it in there.
Okay.
Is there anything else, Mr. Song?
And Your Honor, I apologize, I know I indicated several minutes ago that we were not going to request any additional instructions. However, we would like to request that Your Honor also instruct the jury in our book, which is an outdated manual, so I'm not sure if it's numbered differently in the state's copy, but in the 2018 version of the criminal pattern jury instructions, that's 9.16, instruction on warnings and waiver required for recorded oral statement. We would request that the court submit that to the jury as well.
Can I see what that?
Yes, Your Honor.
Where do you want to put it? Sure. I can see it.
And it is on page 233 of the 2018 edition of the criminal pattern jury instruction.
Okay. So this portion of the whole thing?
Yes, Your Honor.
Give me one second. Can you shoot that? I mean, there was a statement made, the evidence is going to show that there was an oral statement made, and if you asked for it, you have to have it in there. I don't think there was a lot of issue made with regard to the voluntariness of the statement, but I guess you could make an inference or an argument of some sort. There was a suppression hearing earlier during the litigation of this case, so where arguments, I guess, were made during that time. All right, so you're gonna type the language out and send it to me, please. That way I don't have to type it.
Yes, Your Honor.
And send it to the top of the council.
Yes, Your Honor.
Other than that, is there anything else?
Which deputy that reviews.
Any particular place where you'd like that language? I take a look at it.
Your Honor, I don't believe we have a strong position, but I would propose placing it between the application paragraph of count 2 and the paragraph now titled Roman 8.
Paragraph what?
Roman 8, page 4.
Okay, right before 8.
Yes, Your Honor.
And you know, well, you know what? There's no Roman numeral 7, so I can put it 7. Right? Looks like it. I think you have 7 out.
Yes, sir.
So there's a 7.
There's some-
Okay.
So would Your Honor like me to include that in the current full charge of the court as Roman 7?
Yes, that'd be
Okay,
great.
thank you.
And then just, is there anything else we took out? No, we didn't. We left unanimously and we left. Oh, we're gonna put in the
The 2 officers.
right. The alpha beginning. So then can y'all get together on that language and then just send it to me and we'll know.
Yes, sir.
Okay, great. Thank you. And I'll formally ask you. I mean, once we're done with Dr. Shaw, I'll ask you again if there's anything else in the charge, but I suspect that there won't be. So I'll have the charge ready. Thank you. All right, so it's 1:53. We still have a week to go with Dr. Shern, so I think I'm gonna just opt to wait and keep the jury there, and that way once Dr. Shern is here, then we'll do it with her, and then you'll follow up with your defendant 7, you'll publish, and then you'll tell me whether you have any other witnesses or you rest at that time, and then we'll ask the state whether they close, and we'll send the jury out for a bit, and then be right back with reading the instructions of the charge. Okay, thank you.
Okay, so they're off. Let me go over here and see. Make sure I don't touch anything else like the volume. Wow. Let's see where they are. Oh yeah, she's back. And Lord, watch how disgusting that they are when they start to question her. I thought I was right there. I wish she was on the stand.
Judge, we do not believe the state has met their time they shut up.
All right.
Okay.
Your motion is with regard to all counts.
What happened? Oh, stem.
Your motion is denied. Okay, let's bring the jury in. So the defendant's already here, so we can bring the jury in. And let's get Dr. Stern is ready to come in at a moment's notice, yes?
She's in the room.
She's ready, okay.
Why the cameraman got the camera on the ceiling?
Right, jury?
Oh, the jury is coming in. That's why. Come on.
Thanks, everybody. Please have a seat. Mr. Peña, as you know, the state has rested. Do you intend to call any witnesses? Dr. Corinne Stern? Yeah, just over. Now, I believe that you have been sworn in, but since I released you, I'm going to swear you in one more time.
You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you. Come around here, Mr. Chair. Lower the mic a little bit if you'd like. Thank you. Mr. Boggs, you'll be doing the examination.
Yes, sir.
Thank you. You may begin.
Good afternoon, ma'am.
Good afternoon.
Thank you for being here.
Sure.
Ma'am, just so everyone, well, let me start. We did not meet last week. My name is William Boggs. Thank you for your patience. You testified last week as an expert for the district attorney. Is
Yes,
that
sir.
correct?
Yes, sir.
Yes. And I just want everyone to understand your qualifications.
Sure.
And your educational background.
Absolutely.
And that was something about which you testified last week, correct?
Yes, sir. I did.
And ma'am, you do not hold a MD license. Is that correct?
No, not an MD.
You are a doctor of osteopathic medicine.
Osteopathic medicine. Yes, sir.
And could you explain to us what the difference between a MD and a osteopathic doctor means?
Absolutely. So an MD, we call that allopathic medicine, and a DO we call osteopathic medicine. And it's just the type of training during the 4 years of medical school. It's osteopathic medicine is just a little different way of looking at medicine. So we use a more holistic approach, not as in holistic medicine, but in a holistic approach to the body, as in structure affects function. So in other words, we don't want to just treat the symptoms. We want to get to the cause of the symptoms and treat that. So there's a few more courses we take. We go all our summers. We take classes in osteopathic manipulative medicine, sports medicine, and other things that function on looking at the body as a whole, if you will. It's just a different method of teaching while in medical school.
And so, ma'am, you indicated that osteopathic medicine deals with the entire body.
Oh,
Correct?
yes.
So, for instance, the American Association of Osteopathy strongly recommends yoga, for instance. Correct, ma'am? Is that
Not when I was in yoga, wasn't the thing when I was in medical school, but they may now. I don't know.
So, for instance, if you visit the American Association of Osteopathy website today, they will recommend yoga, and I'd say we're all big fans of yoga. Okay, so this is no impugning of yoga, but that is an example of the approach of osteopathy.
Oh, I believe it, because we put a big emphasis on staying physically healthy. So I can understand that they would be promoting yoga. Yoga was just not a popular thing when I was in school way back when.
And you, on direct examination with Mr. Alamese, indicated that you do forensic pathology. Is that correct?
That's correct.
Okay. Now, are you a board certified pathologist, ma'am?
No, I am not.
Okay. And you remember being asked, because you indicated on, I apologize, let me back up a little bit. On direct examination, you were asked by Mr. Alamese about your qualifications.
Yes.
You recall that? And you said that Mr. Alamese asked, and I'm looking at page 146 of the draft transcript, which is, okay, can you tell us a little bit about your education background and your training that qualifies you in this field as a medical examiner? And you answered, sure, I received my undergraduate degree in medical technology from the University of Mary Hardin Baylor in Belton. I graduated from medical school at the University of North Texas Health Science Center in Fort Worth. I have a master's degree in public health. I went to medical school at the university, did my residency at the University of Hawaii at Manoa and Honolulu. I then did a surgical pathology fellowship at the University of Texas Health Science Center in San Antonio, and I did my forensic medicine fellowship with the Office of the Armed Forces Medical Examiner in Washington, D.C. I'm licensed to practice medicine in the state of Texas. I passed my forensic boards in 2001. I'm a member of the National Association of Medical Examiners and the American Academy of Forensic Sciences. You remember that question and answer, ma'am?
Yes.
So when you said I passed my forensic boards in 2001, you did not mean as a board certified pathologist.
No.
Is that correct?
Just my forensic board exam. That's correct.
So now you were asked by Mr. Pena on cross-examination.
Let me do it this way. I think you should approach this.
Doctor, you remember being asked by Mr. Pena what you meant by passing your boards. Do you remember that, ma'am?
I don't remember that question. I remember him asking me the organization that those boards were under.
And do you remember referring to the American Board of Pathology?
That's correct.
Okay. So when you were asked what it meant to pass your boards, last week you said the American Board of Pathology. Am I understanding you correctly?
That's not the question he asked me.
Okay. Ma'am, were you asked the following question, did you give the following answer? Okay, doctor, you mentioned that you passed your boards. What exactly were you referring to? And your answer, the American Academy of Forensic, the American Academy, the American Board of Pathology, my forensic medicine boards given by the American Board of Pathology. Do you remember being asked that question and giving that answer?
Well, I remember him asking me what the organization was. I can't remember word for word exactly. I remember him asking me what the organization was, and I remember telling him I did pass my forensic medicine board.
And would it refresh your recollection to see a copy of your testimony, ma'am?
No, I'm answering you what I remember telling him,
Okay.
which is the same thing. I don't know how else to answer this.
Okay, so last week, and I just want this for the record to be clear, when you were asked by Mr. Pena, right, what you were referring to when you said, I passed my boards, you listed the American Board of Pathology. Did you not, ma'am?
When he asked me what the organization was, yes.
Okay. And so, but today you're telling us you are not a board certified member of the American Board of Pathology, correct?
I never said I was, and I'm not.
So when Mr. Pena asked you what the organizations were, you listed American Board of Pathology, though, correct?
Yes, that's where I took the exam.
But you're not a board certified member of the American Board of Pathology.
No, I am not a board member certified of them, but I did pass my forensic medicine board exam.
And ma'am, in fact, back in 2009, so some 14 years ago, you were one of only 2 medical examiners in all of Texas that were not a board certified member of the American Board of Pathology, correct?
Oh, I have no idea.
That's speculation on her part as to who she answered.
I have no idea.
Okay. Well, in fact, you were contacted by Channel 5 Dallas NBC News for a comment on your lack of qualifications, correct?
I'm going to object to the relevancy of this question. Harassing the witnesses.
I have no idea. I do not remember that. Absolutely not.
And you declined to comment, correct?
I have no idea. I do not remember that at all, Judge.
And the,
No recollection. Okay.
and the other medical examiner who's not board certified in El Paso said he was going to seek his board certification.
That question is improper. Saying.
The witness is testifying as an expert, Your Honor. She's allowed to
He's
defer.
he's testifying from counsel's table, Your Honor. Just rephrase your question.
I can move on, Judge. And then last week there was discussion about your experience in Alabama, correct? You remember that?
Yes,
And you wish you never left Texas. Is that correct, ma'am?
That's
Is that
correct.
my memory? Okay. And you had a poor experience in Alabama where you were the state medical examiner for the Department of Forensic Science, correct?
I'm going to object. This has already been asked and answered. The process of the cross-examined on this topic, Your Honor. It's been thoroughly. I think. Thanks, Dr. I think that they have the opportunity to call as a witness on their side. If they like to do that now, I don't think I can limit that situation. Over.
And the very organization that you were the head of disputed your findings in a death penalty case. Isn't that correct, ma'am?
yes, after I left.
And last week you indicated it was because of defense experts. Do you recall that, ma'am?
Yes, that's what I believe.
It was
Yes,
actually the district attorney who dismissed that case. Isn't that correct?
That's correct.
That was already asked and answered. Thank you.
And ma'am, you said that was after you already left. In fact, you sued the Alabama Department of Forensic Science after you left. Is
I'm
that
going to
correct?
object again. This is badgering and trying to attack her character. Your Honor. It has nothing to do with the qualifications. Anything else I just heard.
I understand. Overruled.
Yes, that's not correct. That was before I left.
You sued them before you left.
Yes.
Okay. Judge, if I could have just one moment to construct the counsel. Sure. And I can have a combative manner. I apologize.
You're fine. Thank you.
I pass the lead.
Any questions?
Hello, Dr. Stern. Let's back up here a little bit and talk and explain to the jury what board examinations and certifications you have.
Oh, okay. So I am a diplomat of the National Board of Osteopathic Medical Examiners. I don't remember the year. I did pass my forensic medicine board exam given by the American Board of Pathology. I believe that was in 2001. I'm licensed to practice in the state of Texas. I am a fellow of the National Association of Medical Examiners, and I'm a member of the American Academy of Forensic Sciences in the biology section.
This other question that they're making a big deal about, which is the being a diplomat.
Objection to the form of question.
You open the door, Ron.
His name should rephrase his name.
That you're not a diplomat of the, is it the American,
That's the American Board of Pathology.
okay. Is that required for the job you do?
No, absolutely not.
Are you a diplomat of any of the boards, any other association?
Well, the National Board of Osteopathic Medical Examiners, I am a diplomat.
Okay, and what are the, I guess, what are the requirements to become a diplomat?
Oh, well, it's a 3-part exam, and you must pass all 3 parts, and I passed all 3 parts
Your American Board of Pathology, when did you pass that exam?
in 2001.
Okay, is that a specialty exam?
Yes, that's a subspecialty exam, yes.
Okay. Now, when you say my boards, what does that mean, my boards?
It's an exam. It's an exam given by an organization called a board.
Okay.
It is a board exam.
Are you familiar with the section under the Code of Criminal Procedure that regulates the medical examiners?
Oh, yes, sir.
And what chapter is that?
49.25 of the Texas Code of Criminal Procedures.
Do you meet all the requirements under that section to do your job?
Meet and exceed, yes, I do.
And how long have you been a medical examiner?
Well over 20 years.
And let me ask you, doctor, is it uncommon that your findings or opinions are contested, or that other pathologists in your field may disagree with findings of other pathologists?
No, that happens in every single trial. You know, the prosecution has a witness, and in a civil trial, the plaintiff has a witness, and then the defense attorneys, they have their witnesses with their opinions. That's what being an expert is all about. We're always questioned. We're always questioned.
Okay. Can I have a approach?
You may.
I'm going to show you what I'm marking on State Exhibit 533. So, you familiar with 533?
Yes, this is a copy of my CD.
And I'm going to ask you if you could go over the section of publications.
Okay.
What is that?
So these are articles in peer-reviewed journals that I've written or co-authored.
Okay. Before you testify from that, I'd like to introduce State Exhibit 533. I need to have a copy of it. Yeah, Judge, 533. Admitted. What this section says publications, what does that mean?
So these are articles in journals, peer-reviewed journals.
By whom?
So you write an article. I did the research. I wrote the article, and then it's there's on every journal there's a list of editors or reviewers, and they have to review the articles and decide if it's worthy enough to be published. They check your research and things like that.
And these are articles you wrote?
Yes.
What was the first article that you have?
Unauthorized border crossing and migrant deaths in Arizona, New Mexico, and El Paso, Texas. I wrote that with individuals from the Center for Disease Control and Prevention.
What's the next one you wrote?
This was Mass Fatalities Enrolled with the Medical Examiner. This is a local journal by the El Paso, I don't know the exact title, but maybe Physicians Association in their local journal.
What's the next article that you published?
That was an antiphospholipid syndrome that has to do with your blood clotting. That was published in Laboratory Medicine.
What about the next one?
Warfarin-induced elevation of the activated partial thromboplastin time. It also has to do with blood clotting. This was an area I was interested in early on. Cervical vaginal cytology in women treated with tamoxifen for breast carcinoma. I did some research to determine if women who used tamoxifen, which is a drug we used to treat breast cancer, was making any difference in their pap smears.
Now, you're also a presenter. Have you had experience of being a presenter?
Yes.
Okay. Can you tell the ladies and gentlemen of the jury some of the presentations and topics that you made?
Yes. Let me just preface it by saying there's been probably a dozen since this, but I do quite a few crossing through the borderland. I do quite a few presentations around the country on border crossing fatalities. Myself and my office are subject matter experts on that just because we see so much of that. That's a presentation I did at the American Academy of Forensic Sciences. I've presented twice at the Border Patrol Symposiums. One was in Arizona. I can't quite remember where the other one was. I've presented at the binational conference between Mexico and the United States on this topic as well. Blood and body fluid precautions with DMORT, that's the Disaster Mortuary Operational Response Team. That is a division of the National Disaster Medical System. I do serve on that team, and I've presented several times at our conferences. Crossing deaths in Webb County, again, dealing with our border crossing deaths. The death certificate dilemma. This was presented here at the Laredo Medical Society, and I've presented that as recent as last year, so multiple times. Also, the state of Texas has me lecture on this to the incoming justices of the peace. They have me on a cycle, I think, every other year. I'm a presenter to teach the JPs on how to properly fill out a death certificate. The role of the medical examiner in mass fatality incidents. I presented that in Washington, D.C. My master's degree is in public health. It has a concentration in mass fatality management. Disaster mortuary operational response team, standard operating procedures. Again, teaching teammates across the country of our policies and procedures. A case of death due to an air emboli in a male. This was a case study I had. It was actually a case out of Alabama. I presented at the American Academy of Forensic Sciences. It was selected to be presented. Sudden unexpected death in infancy investigation, SUDI. We're now getting away from the term SID, sudden infant death syndrome. We now use sudden unexpected infant death or sudden unexpected death in infancy. That's what that mnemonic is for. And I did present at the Centers for Disease Control and Prevention in Atlanta on this topic. Forensic pathology and lessons learned in the wake of Hurricane Katrina. I do serve as a forensic pathologist with the Disaster Mortuary Operational Response Team, and I was deployed to Hurricane Katrina. I spent 7 weeks there. I set up the portable morgue unit and worked. And this was a presentation I was asked to give afterwards with my experience there. Mass fatalities and the role of the medical examiner. Again, that's one of my specialties. I presented that at the State Coroners Association meeting in Alabama. Pediatric autopsy, I was asked to present at the National Child Abuse Symposium. I was approached and asked to present and put a presentation together about the best approaches for a pediatric autopsy, so autopsies in infants and children.
I was also down there.
Yes. Lightning strike fatality in a hunter. This is also a case I had in Alabama. It was selected to be presented again at the American Academy of Forensic Sciences, and I presented it. The forensic pathologist and the role of radiology. I was approached one day, got a phone call from a radiologist with the Mississippi State Association of Radiology Technologists. She had seen a prior presentation and asked me if I would put something together explaining the role of radiology or the role of x-rays in forensic pathology. And I did travel to Mississippi to make that presentation. Texas death certificate and the role of the physician. Again, this is with the Texas Bureau of Vital Statistics. I currently still make that presentation. I'm kind of on a rotating schedule, and about every other year they do call me to make that presentation to the justices of the peace. 9/11 and the role of the forensic pathologist. This was one of the binational conferences with Mexico. I did serve at 9/11. I was actually deployed the night of 9/11 and served in New York. And I was asked again afterwards to present some of my experiences as a forensic pathologist on the ground there. Dying to be thin. This was a case presentation on a patient I had that died from bulimia and anorexia nervosa. It was selected to be presented at the National Association of Medical Examiners annual meeting, and that was a poster presentation. Aerospace pathology. I was asked to make that presentation with DMORT. My specialty where I trained with Office of Armed Forces Medical Examiner is aerospace pathology. Fatal cardiac sarcoidosis in a patient previously diagnosed with Chagas disease. Chagas disease is caused by a trypanosome. This was a case that I had when I was in El Paso. It was selected to be presented at the NAME meeting, National Association of Medical Examiners, and it was a poster presentation. I was a panelist. This was a mass disaster response. This was a conference across the border I was invited to in Mexico, and I was a panelist answering questions related to trauma as seen by a forensic pathologist. Sudden and unexpected deaths from seizure disorders, retro and prospective analysis. This was my subject of research when I was a resident in pathology, and I presented some findings at the American Academy of Forensic Sciences. Texas Society of Pathology, I was a poster presenter. This was actually a poster on interdigitating dendritic cell carcinoma. I had presented it at a meeting in a lecture type presentation, and then at the Texas Society of Pathology, I had a poster presentation of it. Same one, interdigitating dendritic cell carcinoma. Cervical vaginal cytology in women being treated with tamoxifen for breast cancer. Again, I was asked, this was a clinical research symposium I presented to, actually won first place. American College of Clinical Pathology, College of American Pathologists. I was a poster presenter. 97, that would have been with my tamoxifen study. Residence form. When I was a resident and also a fellow, I was our resident delegate, and I presented, I guess, the role of the physician assistants in pathology training programs. These were just presentations I was asked to give. The next one, the role of the pathologist as a vital member of the healthcare team. These were presentations I gave as a resident. Purpose of the nominating committee. These were actually resolutions when we were actually trying to change some laws within our organizations, and so I presented on them.
What were some of your awards?
Golden Key International Honor Society. That was based on grades, I'm sure. Delta Epsilon Tau Honor Society. I think that was during my master's degree. I'm not exactly sure, but again, it was a grade base. I was on the president and dean's list when I was at the university. NPMS, gave me the 2008 Distinguished Team Member Award. That's from the Disaster Mortuary Operational Response Team for my service through the years. The 2005 American Red Cross Hero of the Past, I was nominated for this award along with several other physicians, and I was actually picked to receive it based on, they call it an act of heroism. I was given it, it was based on my work with organ and tissue donation and recovery.
Mr. Alexander,
Yes.
the document's already in evidence. Do you wish to go through the rest of her
I
college
have
accolades?
5 more honors awards coming up.
But- Is there a story to tell on each one of them, or
Including her explanation of each one.
have you went over the dean's list?
Yes. Well, I'll just need it to just finish these last 4. Okay.
Okay, AFIP Fellows Symposium Original Manuscript, 3rd place. That was on research that I did when I was at the Office of Law Enforcement Medical Examiner. Calendar Binford Scholarship. I received a scholarship to do my forensic medicine fellowship. That was typically only open to members of the armed forces, and I received a scholarship to do one as a civilian. 1st place resonance paper competition. That was on my my research with epilepsy and seizure disorders. Again, the Dean's Research Award on the same topic, and then Who's Who in American Colleges and Universities. My medical school nominated me for that.
Your qualifications comply with the Texas Code of Criminal Procedure.
Yes, sir.
Are you currently conducting, or when was your most recent research project? Or is your current one on?
Still working with the Board of Crossers with numbers and still developing policies, the best practice policies and procedures.
Now, you weren't the medical examiner that performed the autopsies in this case, correct?
No, sir.
But you did testify last week as to an opinion as to the injury on Lady Dominic's leg, correct?
That's correct.
And do you still stand by that opinion?
100%.
And in your opinion, was it caused by a spider or insect bite?
No, it was not.
And what was your opinion as to what caused that injury?
This was a puncture wound. It was a deep puncture wound. In my opinion, it was caused by a large bore needle. That was most consistent with the injury that I saw.
Thank you, Dr. Smith. That's absolutely.
You've received a lot of awards. Is that what we would understand, Doctor?
Yes.
Okay, so I'd really like to talk about your testimony here last week, because today, as I understand, you're saying that you were not certified by the American Board of Pathology. You only passed the exam in 2001. Is that correct?
That's correct.
Right. You remember being asked by Mr. Pena when you were certified by the American Board of Pathology, and your answer being it was in 2001?
No, he never asked me about certification.
So, ma'am, were you asked the following question, the following answer? Question, I see. So, and what day did you get certified? Answer, it was in 2001. You didn't.
I don't remember that question. I don't.
Would it refresh your recollection to see a transcript of your testimony?
Well, I believe what you're telling me.
And I apologize. That's very kind. But would it refresh your recollection to see it?
I don't think it's going to make me remember him using the word certification.
So I just want to make sure the record is clear. You're denying that you were asked that question, or you do not recall whether you were asked that question?
I do not recall that question.
And you're saying it would not refresh your recollection.
I can see it, but I don't independently recollect being asked that question.
Now, on the state's examination just now by Mr. Albanese, he indicated, and he specifically pointed out some conferences that you presented at in Alabama, correct?
Yes.
Okay, and that was in 2006, correct?
I think most of them were in 2006.
Now, all of those conferences were before the November 2006 Alabama case that we have discussed here in court, correct?
I don't know. I don't know that. But
so once you left, for instance, the Alabama Forensic Commission, you were no longer presenting in Alabama on, for instance, pediatric autopsies.
no, I was no longer presenting in Alabama.
And in fact, all those conferences that Mr. Albanese went through, right, pediatric autopsies, you didn't present on them anywhere, not just in Alabama, correct?
I'm sorry, what is your question?
You presented in Alabama in 2006 on pediatric autopsies.
Yes.
Okay, and you said you no longer presented in Alabama on pediatric autopsies. But the truth is, according to your resume, you didn't present on pediatric autopsies in any jurisdiction. Is that correct?
I guess I still don't understand your question. Alabama is a jurisdiction. I presented there.
After November of 2006,
Have I presented?
on pediatric autopsies in any jurisdiction.
Yeah, I believe I have. They're not on that. They're not on that CV there. But yes, I've presented at JP conferences on pediatrics. I have.
Okay. On pediatric autopsies, maybe?
Yes, that's what I do. Autopsies. Yes.
But it's not in your resume.
No, it's not in that resume. There are probably many, many more presentations that I haven't listed. That's the resume gets 6, 7, 8 pages. It's, I put some pertinent things on there. And,
Just if I could step one minute, I apologize.
Anything else? Oh, yeah. Thank you. You are now released. You can go back to business. Thank you. Thank you for making time here. 5:50 was. Yes, it was a minute. Thank you. Mr. Peña, do you have any other witnesses?
No further witnesses, Your Honor, you can say some medical record.
Very good. Thank you.
Judge, at this time, we move to admit under the business records exception that's been provided to the district attorney, defendant's exhibit 7, which is a self-authenticating document put out by Tanya Cortines, dated March 29th of 23. It's 105 pages.
Defendant 7, any objection?
Judge, at this time, I'd like to publish. The document is 105 pages in total. We just have 5 pages to publish to the judge.
Go ahead. This document has been introduced and admitted into evidence. There's been a request to publish a certain number of pages of that document. And Mr. Boggs will do that right now.
The record is page 29 of 105. Change the page. This is now page 44 of 105.
Fine.
For the record, I'm publishing on the projector, page 47. Changing to page 60. 105. Now changing to page 70 of 105. For this exhibit, Judge,
Excuse me.
I'll correct the pages in the
Defendant 7 then has been admitted. You would. Approach.
He's busy. He's saying to himself, I got other things to do than to wait for this life sentence. Idiot. Idiot. Okay, Laura. No worries. This is a long bench conference. A long bench conference. This is a super long bench conference. I want to go past this, but I don't want to speed up too much because they should be starting again. But this has been a pretty long time that they've been at this bench. So yeah, let's try to go ahead and see if I could skip to a point where they actually start. They still at the bench. And now they're going, okay, let me get past this because, all right, he's back right here.
Any objections to the charge of the court other than the ones already posed?
There are a couple of sort of, when the court reads this, doesn't stumble over this, I think we should just write it
Thank you.
So in the third paragraph, it says, an oral record statement, I believe it should be an oral recorded statement by a defendant. I think that might be a typographical error.
Just for the record, you all typed this one out,
I
right?
agree,
Yeah.
it was typed up just a few moments ago, right? There's a second one on page 5, the first full paragraph at the top. If you do not find that state, I should say, if you do not find that the state has proved these things,
Thank you.
and those are the two typographical.
I have, I'm going to read it as the way that you have just suggested that I do, so I don't stumble with my words. And I appreciate you telling me that. Thank you. And in fact, the original one is the one that I have here. The rest will be a working copy for both you all and the rest of the jurors. Other than that, anything else, Mr. Pena?
Nothing else, Your Honor.
No further objections, no further inclusions. Is that correct?
That's correct, Your Honor.
Very good. Oh, you know what I don't have here? The verdict form. That one did not change.
Your Honor, we did add unanimous to the verdict form as well, but that was provided to the state last night and we made no revisions today.
I don't think that one was sent to me. Can you send it to me? No? No, let's see. There's a verdict form that I have that says verdict of the jury defense revised, but that one was sent to me way back then. That was not it. Can you tell me where?
Yes, Your Honor.
I have it here. I don't know if you can see it. Okay, I know that, right? Okay, I'm gonna go print this out at the color one. I think this is the only one. I'm gonna print one for them, for the parties, and then for the one that we're gonna submit to the original. So I'm gonna print them out already here. Yeah, so I'm gonna give 5 of them there. I think. Let's make it 6 because one for Cindy. All right, thank you. Did y'all get what they? I think they wanted one over there. Did we have an extra copy? Solis, where are you? Okay. I think they wanted one over there. I don't know if they got one over there in the back. Did y'all get one? Can we get it? Yes, somebody. I mean, you want it? Give it to them. Can I take it? Yeah. Take it. Did I do it? Okay. Uh-oh. I have 2 chargers. I'm not sure which one. Pretty sure it's not this one. Oh, yeah. That's enough. It's the same one y'all had already prepared. Cindy, do you have a whole copy? There's a verdict form. Okay. Huh? And then this will be the original one that I work with. I'm gonna go ahead and have you file stamp it after I sign it. And let's get the jury ready, please. Thank you. Sure. Thank you. You're good? Okay. Oops. What happened with this one? Oh, this was this. Okay. Make sure they get the jury right now. Huh? Mr. Alanis, you want to divide up your time? Very good. I'll give you a 5-minute heads up on both ends. 10 minutes, okay. 10 minutes reserved. Okay.
Closing arguments. It's going to be pretty interesting.
Thank you all. Please have a seat. Members of the jury
instructions first.
I'm about to read you the charge of the court in cause number 2018 CRA 852D1, the state of Texas versus Ronald Anthony Burgos Aviles. The case filed here in Webb County, Texas, in the 49th Judicial District. Members of the jury, the defendant, Ronald Anthony Burgos Aviles, stands charged by indictment with 2 counts of the offense of capital murder, alleged to have been committed in Webb County, Texas, on or about the 9th day of April 2018. The defendant has pleaded not guilty. Our law provides that a person commits the offense of murder if he intentionally or knowingly causes the death of an individual. Our law provides that a person commits the offense of capital murder if he commits murder, as hereinbefore defined, and the person intentionally or knowingly causes the death of more than one person during the same criminal transaction. Our law provides that a person commits the offense of capital murder if he commits murder, as hereinbefore defined, and the person intentionally or knowingly causes the death of an individual under 10 years of age. A person acts intentionally or with intent with respect to the nature of his conduct or a result of his conduct when it is his conscience, objective, and desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the result of his conduct or to the circumstances surrounding his conduct when he is aware of the nature of his conduct or that his conduct is reasonably certain to cause the result. Individual means a human being who is alive. You are instructed that you may consider all relevant evidence concerning the relationship that existed between the deceased and the defendant, if any, prior to the alleged killing, the facts and circumstances surrounding the alleged killing, and all of the relevant facts and circumstances showing the condition of the defendant's mind at the time of the alleged killing. Our law provides that the time of the offense alleged in the indictment must be some date anterior to the presentment of the indictment, and not so remote that the prosecution of the offense is barred by limitation. The phrase on or about means that the state is not required to prove the alleged offense happened on that exact date. There is no limitation period for the offense of murder and capital murder. Therefore, it is sufficient if the state proves that the offense alleged was committed sometime before June 27th of 2018, which is the date the indictment was filed. Any words not specifically defined are to be given their ordinary meaning, and jurors are free to use any meaning which is acceptable in common speech. Count 1. Now, if you find from the evidence beyond reasonable doubt that on or about the 9th day of April of 2018 in Webb County, Texas, the defendant, Ronald Anthony Burgos Aviles, did intentionally or knowingly cause the deaths of Dominic Alexander Hernandez and Grizelda Hernandez during the same criminal transaction by stabbing Grizelda Hernandez multiple times with a sharp object and by stabbing Dominic Alexander Hernandez in the chest or slashing Dominic Alexander Hernandez's throat with a sharp object, then you will find the defendant, Ronald Anthony Burgos Aviles, guilty of capital murder as charged in the indictment. Unless you so unanimously find beyond reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of murder and say by your guilty or by your verdict, not guilty. Count 2. Now, if you find from the evidence beyond reasonable doubt that on or about the 9th day of April 2018 in Webb County, Texas, the defendant, Ronald Anthony Burgos Aviles, did intentionally or knowingly cause the death of Dominic Alexander Hernandez, an individual under 10 years of age, by stabbing Dominic Alexander Hernandez in the chest or slashing Dominic Alexander Hernandez's throat with a sharp object, then you will find the defendant, Ronald Anthony Burgos Aviles, guilty of capital murder as charged in the indictment. Unless you so unanimously find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will acquit the defendant of murder and say by your verdict, not guilty. You have heard evidence that the defendant made an oral and recorded statement on April 9th of 2018 during custodial interrogation conducted at the Laredo Police Department by Laredo Police Detective Rick Reyes and Ernesto Elizondo. If you find the defendant did make the statement, you may consider the statement against the defendant only if you resolve a preliminary question in favor of the state. An oral recorded statement An oral recorded statement by defendant, should say recorded, by defendant made as a result of custodial interrogation may be considered only if before the statement, but during the recording, 1, the defendant was warned that A, he has the right to remain silent and not to make any statement at all, and that any statement he makes may be used against him at the trial. B, any statement he makes may be used as evidence against him in court. C, he has a right to have a lawyer present to advise him before and during any questioning. D, if he is unable to employ a lawyer, he has a right to have a lawyer appointed to advise him before and during any questioning. And E, he has a right to terminate the interview at any time. And 2, the defendant knowingly, intelligently, and voluntarily waived the right set out in the warning. Therefore, you may only consider the statement made by the defendant to Detectives Reyes and Elizondo on April 9, 2018, if you all first agree that the state has proved beyond reasonable doubt that before the statement was made, but during the recording, and the defendant was given the warning set out above, and knowingly, intelligently, and voluntarily waived his right set out in the warnings. If you do not find that the state has proved these things beyond reasonable doubt, you must disregard and not consider for any purpose any statement the defendant may have made. If you do not find the state has proved these things beyond a reasonable doubt, you may consider the evidence that the defendant made the statement and give that evidence whatever weight you believe appropriate. I may have said if you do not find, actually, if you do find. Paragraph 8. You may consider all of the facts that are shown by the evidence, and to draw natural and reasonable inferences from such facts. You alone have the authority and the duty to determine what the facts are in the case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with an offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant. Unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. In a criminal case, the law permits the defendant to testify in his own behalf, but the same law provides that his failure to testify shall not be considered as a circumstance against him. You will, therefore, not consider the failure of the defendant to testify as a circumstance against him, and you will not, in your retirement, to consider your verdict, allude to, comment on, or in any manner refer to the fact that the defendant has not testified. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution proof excludes all reasonable doubt concerning the defendant's guilt. You are further instructed, as a part of the law in this case, that the indictment against the defendant is not evidence in this case, and that the true and sole use of the indictment is to charge the offense and to inform the defendant of the offense alleged against him. The reading of the indictment to the jury in the statement of the state's case against the defendant cannot be considered as a fact or a circumstance against the defendant in your deliberations. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. It is improper for a juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror nor consider it themselves in arriving at a verdict. You shall not discuss or consider the punishment, if any, which may be assessed against the defendant in the event he is found guilty. You may not discuss this case with any court officer or the attorneys or anyone not on the jury. You must not discuss the case unless you are all present in the jury room. If anyone leaves the jury room, then you must stop your discussions about the case until all of you are present again. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. You must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. You must also disregard any statements of the attorneys that is inconsistent with the law contained in this charge. The role of the judge is to preside over the trial and to rule on objections and the admissibility of evidence, but not to comment on the weight or credibility such evidence is to be given by the jury. Therefore, the jury shall not draw from the conduct or comments of the judge any inference as to the weight or credibility of evidence admitted before them during trial. You have been permitted to take notes during the testimony in this case. In the event any of you took notes, you may rely on your notes during your deliberations. However, you may not share your notes with the other jurors. and you should not permit the other jurors to share their notes with you. You may not, however, discuss the you may, however, discuss the contents of your notes with the other jurors. You shall not use your notes as authority to persuade the fellow jurors. In your deliberation, give no more and no less weight to the views of a fellow juror just because that juror did or did not take notes. Your notes are not official transcripts. They are personal memory aids, just like the notes of the judge and the notes of the lawyers. Notes are valuable as a stimulant to your memory. On the other hand, you might make an error in observing, or you might make a mistake in recording what you have seen or heard. Therefore, you are not to use your notes as authority to persuade fellow jurors of what the evidence was during the trial. Occasionally, during deliberations, a dispute arises as to the testimony presented. If this should occur in this case, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute because the notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. You are the exclusive judges of the fact proved, of the credibility of the witness, and of the weights to be given to the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed thereby. After the reading of this charge, you shall not be permitted to separate from each other, nor shall you talk with anyone, not of your jury. After argument of counsel, you will retire and select one of your members as your foreperson. It will be his or her duty to preside at your deliberations and to vote with you in arriving at a unanimous verdict. After you have arrived at your verdict, you may use the form attached hereto by having your foreperson sign his or her name to the particular blank that conforms to your verdict for each count. But in no event shall he or she sign more than one of such blanks on such form. I have the original, which does have the verdict form. Your copies that you have with you are your working copy that you can keep to assist you during deliberations. The original has on top, says original copy, and is signed by me. And it also has the corrections on some of the words that I delineated. We'll know exactly which the original is. And this will be the one that the foreperson will have and will sign when the time comes. Mr. Anis?
Your Honor, I'll request an hour and 5 minutes, and I'll reserve 10 minutes. May it please the court.
Take them to school, Annalise.
Ladies and gentlemen of the jury, it's time. It's time. More than 5 years ago, 2 innocent lives.
He wants to get to it.
Time has gone by. Court proceedings have been held. We've lived through COVID. Court dockets move slowly.
Mm-hmm.
But throughout all of this time, 2 beloved individuals have been missed by their families, by their community. Grizelda and Dominic. And this is why we're here today. This is who we are here for. Think back to the day on May the 2nd, when close to 400 people, 400 Arrayans like yourself, came together at TAMIU. You answered the call. Your civic duty. You showed up, not knowing what type of case you were going to hear. Little did you know that you would be part of one of the biggest cases in the history of the rape.
Mm-hmm.
When you came to court and were selected for this very big and important case, you rose your hand. And you made a promise. You each remember sitting in this witness chair as we questioned you to find 12 fair and impartial members of our community to hear this very big and important case. And you answered the call. And you are now in the box. It's time. You remember when we were at TAMIU, I made you a promise. And that promise was that the state of Texas would give you a professional presentation of this case.
And they did that.
And we have worked hard and diligently to bring you all of the evidence. Because we spoke about that. That's how important this case is. It's important to Mr. Burgos. But it's important to the state, it's important to the victims, it's important to the community. Because what are we seeking? What are we after? Through all the evidence, through all the facts. Truth. Truth. And we have spent the last 7 days bringing you evidence, seeking the truth. And I submit that we have proven the truth beyond a reasonable doubt. Why do we go through all this trouble in the United States of America? For justice. For justice. Justice for the victims. Justice for the accused. We have all the faith in each and every one of you to make the right decision. And the only decision in this case. And what is that decision? What is that verdict? Each and every one of you know, when you use your common sense, when you review all the evidence, when you weigh all the credibility of the witnesses and of the evidence, you know the answer. You know the answer. It doesn't matter what I believe, it is what the jury is going to believe. You remember that statement during the interview? Remember Detective Reyes telling that to this man that is sitting here today? He couldn't be more right. It's what you believe. It's what the evidence shows. Now, I told you in opening statement, I said, we're going to take you to Father McAdoo Park. We're going to take you to that dirt trail. Now, we didn't put you on a bus and take you. But how did we take you there? We took you there with evidence, with videos, testimony, photos, physical evidence, forensic evidence. We have accounted for almost every minute of his movement on April the 9th of 2018.
Sure did.
Think about that.
Mm-hmm.
Think about that. And we've narrowed it down. You heard me ask the question to lead detective Grizelda Garcia. When that last Snapchat was sent, well, she was still alive. She was still alive. Remember the time? Remember what time it was? 9:44. 9:44. She made that 10 to 12 to 13, 14-minute walk, pushing her stroller, pushing her baby with his Doritos, holding his phone into the trap. 9:44. 10:10. He's on the camera. The other time that we can't account for are those 5 minutes behind the church. Remember that? What happened behind there? Why would he go on April the 7th to scout it out and then go back there after he got in his Kino unit when he left the house at 10:37? What was he doing back then? Use your common sense. I told you in opening that Ronald Anthony Burgos Aviles is a danger. He is a danger to the family, to Grizelda's family, to law enforcement. Argument, Your Honor. What did Detective Garcia say when he heard the transmission from Gilbert Benavides to Anthony Burgos? Grizelda went to go visit her ex or her baby's father, Anthony Burgos. What did the detective testify? He had a surge of adrenaline. He felt fear. He felt fear for his fellow officers. The killer was among them. He was armed. He was dangerous. And he's a danger within society. Why? Because he hides behind the badge. Credibility.
Mm-hmm.
Instant credibility. I told you in opening that every story has a beginning, a middle, and an end. This story didn't start on April 9th, 2018. I told you in opening that we're going to go back to the beginning of how this started. It started in 2015. That's when they meet online. They enter a secret relationship. She gets pregnant. And little baby Dominic is born when? On July the 26th, 2016. In the beginning, it's Grizelda Hernandez, Dominic. And who's missing from that relationship? Ronald Anthony Burgos Aviles. What did the evidence show? The evidence showed that for the first 18 months of this baby's life, Grizelda raised, supported, used her student loans, her daycare, Not a single penny, not a single dollar given by the presumed father. What does she want? What does she want? She wanted what every mother would want. She had dreams. You saw in her text messages to Anthony and also to her family. She was studying to be a nurse, like her big sister Angelica. She had ambitions. You saw, you read her words where she didn't want to cause this guy any trouble. She even said, maybe even before the baby turns 18, I won't need you anymore. But right now it's hard as hell. Help me out. I'm not trying to be mean or anything. The text messages are there, ladies and gentlemen. You'll be able to read them. All the evidence that we brought, all the evidence that we put on this projector, you're going to have it. You can review it. She had hope. She had hope. And you know, hope is a very powerful emotion. Hope is something that keeps dreams alive. It helps keep dreams alive. Hope is something that gives people inspiration. What did she want? She wanted her baby to be loved. She wanted her baby to be accepted, to be acknowledged. It wasn't anything monumental, but it was something very important. She wasn't out to wreck his life. What would have been wrong? Giving this little beautiful baby a chance. What would have been wrong with that? He never gave him a chance. The most innocent of our society, the most vulnerable of our society are our children. Our children. They don't get to select who their parents are. And parents have a responsibility to love their children. It's not that hard. It's not that hard. But what happens in this case? You saw the practice text when she texted herself saying, hey, I don't know how to tell you this, but I really need help in December. And then in January. We took you into the inner discussions between Grizelda and Ronald Anthony Burgos Aviles to show you how he was manipulating her. He would play the guilt game. I started to have a heart 2 days ago, but not anymore. Then he would go into the sex talk, but he would never reveal his rage. Very careful not to scare her away. Very selective on how to bring her near so that he could have that opportunity. Time was running out. Time was running out. His reality check is when he gets the child support paperwork. What does that mean? What did it mean in his life? Threats. He perceived that action as threats. Threats to his marriage, threats to his job, to his career, his lifestyle, his bank account. Who was the biggest threat? His little baby was the biggest threat. Remember I told you, pay attention to the details. Pay attention to the details. You know what? We're lawyers. We go through this over and over and over again, preparing ourselves, but we're only human. Study the evidence, the details. One of the details I noticed was that he never calls Dominic by his name. The baby. And Nene. Why? How's Dominic? What's wrong with saying, how's Dominic? Give him his name. Call him by his name. Not even that. The threat is this innocent little baby. And who does he have to get through? Remember? The mama bear. What does every mother do? Every mother will protect. Every mother will fight. Every mother will die to protect the child. The first meeting in Winfield. It's there. It's there, black and white. Evidence of the first meeting that he set up. We brought you the analysis by FBI cast agent. Putting them there. We put them both at the park on March the 25th. I put up there is the insect bite in quotation. There's been a lot of testimony on the insect bite. Again, use your common sense, okay? Use your common sense. Go back in time with the evidence that we brought you, and it is perfectly logical. It is perfectly logical that everyone in the medical community, even her own sister, a registered nurse, thought it was an insect bite. There is no way that anybody could even fathom that somebody would inject a baby. Do hospitals, do emergency rooms, do pediatricians, do clinics make mistakes in diagnosis? Yes, they do. Yes, they do. And what is the number one factor that every physician, every ER room, every clinic relies on when any patient goes in? The history provided by the patient or caretaker. Those were the working conditions or diagnosis that the doctors were working with. They worked with what they got. And yes, there was one expert after the fact, after the plane crash, go in and do the forensics that's able to say, hey, wait a minute, this wasn't an insect bite. One person who had the expertise and the courage to come here and call it what it was. And we had to, and she was brought back twice and raped through the goals. You be the judges of Dr. Stern's testimony. Use your common sense. Who mentions it first about necrosis? He does. You know he can get necrosis, right? He does. What happens on April the 4th of 2018? Stops communications on Facebook Messenger. Here they are. These are the Facebook records that law enforcement got. Same time period. He sent us on top. Anthony Burgos Aviles on the bottom, side by side. He sent us and his what happened to the communications that he had leading up to the murder. They're gone. You'll have this. But they are in hers. It's in the details. Look at that little ghost on the Snapchat. Remember I asked Detective Garcia, well, what's the deal with Snapchat? What's the advantage? Well, they delete. And I said, you mean they disappear? He goes, yes, they disappear. The messages show up and they disappear into space. That man, Anthony Burgos Aviles, switched his comms, his communications to Snapchat, leading up to the murder. Followed the evidence, intentionally, knowingly, planning. The final meeting, you have the text message from Grizelda to her sister asking her for the white car. Remember the white car? That famous white car, the Mercedes that he, and we'll get into it, but when he goes into the interviews, I don't know what white car, I've never seen that white car. Lies. You saw through the communications how he even talks to her. Are you in the white car? Remember when they get to the Winfield Park? Is that you in the white car? Manipulation, deception, lies. All of that is evidence. April 9th, 2018. The timeline. Through the concerted effort of law enforcement, the DA's office, Laredo Police Department, FBI, Customs and Border Protection, everyone, all hands on deck. Double homicide. All the resources to find the killer. We brought it to you. You saw the level of investigation that was done. From the moment he left his house, we have the video. When he arrives at the Border Patrol station, in his uniform. In his uniform. You remember, and I'll get into that right now. The morning of April 9th and 8/29, remember his vehicle is body or marks at the crime scene. It's at the crime scene early that morning. Grizelda and Dominic arrived around 9:05. He Snapchats at 9:27. The Snapchat records are in evidence. We went over them with you. You see that? The sender and the person who received it. Grizelda's final Snapchat at 9:44. She was still alive. Probably walking and getting near the dirt trail. The radio GPS places Burgos Aviles at 9:49. Remember, what did Miss Stevens say when you turn off the unit? The GPS marks. Remember that at 9:49? What was the next time? 10:10. Twice he turns it off. She's walking into the trap around 9:45, 9:46. The last transmission we have and photograph that you saw off of the camera, the drawbridge camera from DPS is at 10:10. 16 minutes. In there is when he took 2 lives. He departs the crime scene at 10:10. He arrives home in shorts. You saw it. He was in uniform that morning. He's arriving at home with shorts and tennies. 10:37, 10 minutes later, he's getting back in his kilo unit 66119. As he's stepping on, watch the video, you'll see he's in socks. You'll see he's not wearing his boots. Where are his boots? His boots are in the kilo unit. He puts them on. Phones travel with him with Burgos Aviles. The phones. Teléfonos. Teléfonos. He forgot the phones. He speaks to Agent Dennison, Michelada. 11:18. That's when he discovers the body of the female.
Copy 66. Bro, I need your help right here, bro. My Bristol man. And I'm going to say, my EMS ASAP at the end of Bristol. We're Bristol on the River Road 80 from. This is subject unit help, basically. I don't know yet, stand by. Let me go check. Just have to come over here. Yeah, I'm here with any of the agents in this way. I'll just stand by. Stand by.
The crime scene. The crime scene. 11:18. He goes back to that brushy area along the river where he lied in wait. He used his skills. He used the brush. He used the camouflage to ambush. And with vicious and violent blows, attacks Grizelda. The evidence is there. It's in the autopsy reports. But panic equals mistakes. Panic equals mistakes. You remember, you saw the photos, the phones. These were found in Kilo Unit 66119. Grizelda's and Dominic's phones. Can you imagine the amount of adrenaline and fear running through his veins after he just killed 2 innocent people in cold blood? One being his own son and the mother of that innocent baby. And then trying to stage the crime. Can you imagine the adrenaline rush running through the veins of trying to get out of there and make it look like someone else attacked these 2 people? And that's why he made mistakes. That's how those phones ended up right here, right on his vest. And that's why his belt keeper that holds his Sam Brown, where's the these belt keepers, you heard officer after officer testify. How many of these are standard in order to hold this up to your belt? 4. This one, full of dirt, full of mud, found under the driver's seat with Grizelda's blood. She marked her killer. She marked her killer. You have the photos. The dirt trail tells a story. Remember, I told you that in opening. That dirt trail that we took you there with all of the evidence, all of the photographs, the video, it tells a story. It tells a tragic and horrific story of the last seconds of two people's lives who life should not have ended that way. It is hard to comprehend why people murder. That's not, motive is not an element. No matter what reasons he had, he did not have a right to end the lives. Not like that. Not the way he did. Not a law enforcement officer. Not a young mother. Not an innocent baby. She went there that day with hope that he would accept his son. This is how he left her. This is how he left her. You know what? Maybe it was some dogs. Maybe she got beat up last night. He had the audacity to say that. And this is how he left his innocent baby. Drenched in blood. It's in evidence. 5 or 6 bags of hair found on the trail. Hair, long strands of hair that were cut off. You saw the number of clusters of stab wounds to the back of her head. Long hair on the dirt trail. The bloody rock, drenched with her blood. What does he do? He walks over the trail, takes the rock, moves the rock, drags his feet. You remember all that testimony. The shoes. The left shoe, he comes walking and throws it by her body. The right shoe found over there by the river, trying to make it seem like she was coming from the riverbanks, staging the crime. What did I tell you? What did I tell you at jury selection? The biggest enemy that law enforcement has in trying to solve a crime is time. Who decides where? Who decides when? Who decides how to commit the crime? Who's able to plan it? He's able to plan it. He's able to decide when, where, how. That's what the evidence shows. Every little detail. You have it. Maybe Dominic speaks to you guys for this innocent blood. When his fresh haircut that the officer for test testified to, you just need to listen. All you need to do is listen. And if you listen, you'll learn. Look at the evidence. Look at it. Listen to it. Learn from it. It's there. Look at the shirt. Do you see where the knife went through the shirt? Do you see where the knife went through the shirt? Do you see where that knife went into that 1-inch penetrating cut to the chest? No. You don't see it because it's not there. The person who punctured that little sternum didn't go through the shirt. He lifted the shirt. He lifted it. And he went for the heart. That man who sits here today, the United States Border Patrol supervisory agent, he went for the heart of this innocent, beautiful baby boy. Dominic's clues. Listen. He speaks to us. How does he speak to us? Little Dominic put his blood everywhere so law enforcement can find it. So that Ms. Nicole, who came here And she said, well, let me tell you something, Mr. Boggs. It may be meaningless to you, but it's not meaningless to me. Remember that? It's not meaningless to me. I do the analysis. I make the match with what I got. There was no contamination in this case. There was no contamination. The evidence was preserved. The chain of custody was followed. It was taken to the lab at their county. You got that expert who came over here with no agenda, no motive, no conspiracy, but only to tell the truth. And what did it show? You have the DNA results. Dominic's blood on his mother's phone and Mama's blood on Dominic's phone. Mama's blood on Dominic's phone. What does that tell you? What does that tell you?
Sad.
He kills Grizelda. His hands are full of blood. He goes to Dominic's stroller. He unbuckles him with his hands full of Grizelda's blood. It's on Exhibit 4. Nicole told you, Grizelda's blood on the stroller. Where I told you, he unbuckled the baby. There's blood splatters on the canopy where she was attacked from behind, and the blood falls on the canopy. The fight goes 20 to 25 yards down the dirt trail until she finally loses the fight. She's overpowered by strength and violence. He goes, gets the baby. He's probably playing with his phone. He puts her blood on his phone, on that cricket. He takes him over, he kills him. Then what? I need to go get her phone. And he goes back, he grabs Grizelda's phone, and guess what? He puts Dominic's blood on her phone. He throws him in the truck, then he's full of blood. He goes by the tailgate. There it is. He rubs the tailgate. Maybe when he's taking off the pants. Maybe when he's leaning, trying to take off the tennies. Blood transfer. Dominic says, tag, you're it. That's the killer. You need to listen. Look at that. And then the blood inside the truck. The blood flakes. Blood everywhere. He didn't count for that. He did not plan for that. He did not plan for that fight. Grizelda speaks to you also with her blood. Her blood on the rock, her blood on the stroller, on the canopy, on the bellkeeper, and on her little angel's phone. Her blood. It's all there for you. His statement. Voluntarily knowing in his training. You have it. You have it here. The Miranda warnings. You saw the recording. What did it say? Let's just get to it, man. Come over here. I want to talk to you. Let's just get to it. This is a law enforcement officer, okay? This is not your ordinary Joe Blow. This guy, he's a supervisor. He's taking courses. He's certified. He's taken courses on crime scene preservation. You have it right here. He's got the transfer of physical evidence in here. These are the courses. This guy, he moved up through the ranks there at Border Patrol. Miranda training, States Exhibit 515.9, right here. You can't say that he didn't know what his rights were. Because he's somebody that has sat on the other side of the table reading Miranda warnings to people who he made arrest. He's knowledgeable. You saw his demeanor in that room. You saw the charades he was playing, the act that he was putting on. Well, I don't know about that shit about crime scenes. Really? Basic, but Lara does? Edison does? No, I don't know anything about that. Deflecting. Always deflecting. Now, you have the benefit now of sitting here for 7 days and getting all the evidence. What he didn't know back then, as he sat there on April the 9th, was that all of his lies were going to be exposed through a thorough investigation. Okay, so now we have the benefit of the investigation to compare to his statement back then at the time. And you get to see how he's attempting to manipulate the situation. These are just some examples. Well, there's a dead body, there's dead people. Listen to his statements throughout the initial stages. He uses people. Was it a person? It was a girl. Starts getting confused. We are the Border Patrol. We don't got shit about crime scene shit. That's what he says. That's not true. I mean, she could have been unconscious. I can't. What do you say? I don't want to call in and say she's dead. I mean, every law enforcement officer was there said she was deceased, right? So what does he do? He wants to deflect. He says, maybe she was unconscious. And he says, well, Lara said, I don't think she's gone yet. You heard Agent Lara. We're going to go over his testimony. Agent Lara never said that. At the time, I only thought she got beat up. This is the woman who has his baby, okay? This is the woman who has his 18-month-old son, who he denies. He denies her. Lara said something about dogs. I found the shoe. I found the stroller. You didn't find the shoe, did you? The shoe that he brought over? Then he tries to take credit for finding the stroller. You heard Agent Dennison? You heard Agent Dennison? I don't know whose car it is. How many times through the evidence did you see the white Mercedes being discussed prior to this date? And he has the audacity to sit there and tell two homicide detectives that he doesn't know, he's never seen that car before. And then, well, maybe I've seen that car. Right? Lying. That was the first time he saw that car. Well, it rings a bell. That was the most they got out of him. It rings a bell. Well, I saw her 2-3 weeks ago. It's like you killed her this morning. If you snapped, what did Reyes tell missing, man? You know, just tell us the truth, man. I don't know, the last time I saw her was 2 or 3 weeks ago. Last time I talked to her was about maybe a week ago. Oh, dude, you just do. And he's real smart. He goes, check the phone. Check the phone. Thinking about Snapchat, right? Those messages disappeared. So he's challenging the law enforcement. Right? She was smarter than him. She took some screenshots of some of the Snapchats, remember? She went into that tile, takes a screenshot. Something in her told her not to trust him. And she took those screenshots. I wasn't supposed to meet shit, no one. Continue. He denies meeting the child. Hard to explain the situation for the fucking jury. If you're looking for me to say I shot her in the face, I can't do that shit, man. You know why? Because I'm not going to fucking jail for something I didn't fucking do. He likes to throw out the F-bombs as a default. I don't know if you noticed that every time he's confronted with the truth, he starts throwing F-bombs to deflect. Because of this shit, because I hit it 2 years ago, I'm fucking guilty of it. Because I hit it 2 years ago, because he got her pregnant. Listen to the way he's talking about the person that he just killed. No remorse. It ain't fucking fair. You saw it. You listened to it. He says that. It ain't fucking fair. No. It was never like that, man. She was never on you like that. I'm telling you, she's not that type of person. And she was never like that. Oh, you better man up and this and that. It looks like she took a beating from last night or whatever. It's a fucking major coincidence. You know what? He's right. He is right about one thing. She wasn't out to destroy him. She wasn't out to ruin his life. She just wanted support for his baby. Man up. Help me out. This little boy that looks like you. Almost identical to his own son. Mm-hmm. Never a moment of clarity. Never a moment of saying, wait a minute, what am I doing? There was still time. There was still time after he killed Grizelda. There was still time to stop. Leave the baby in the grass. Stop. That tells you how depraved of a heart he has to follow through. And when Dominic didn't die with the first stab, what does he do? He transects the jugular. The carotid. It's not a mystery. I know what's coming because I'm not fucking stupid. I know what's fucking coming. I can freaking easily show you guys that me and her were fucking good. I never had an issue with her. That's right. That's right. Never had an issue with her. So why kill her? I won't give you fucking shit. Remember when he asked me, let us see your phone. Let us help you. You know, we want to help prove, clear you from this. When you see your phone, I'm not going to give you fucking shit. No way. I'm not giving you the password of my phone. I didn't speak with her today. Probably, I'm going to apologize for. You're going to apologize for investigating me. I'm going to want an apology when all this is done. And then Reyes walks in and he's like, well, I was just telling him about the child support. Remember, he's all like, hey, dude, you didn't mention that. Dude, what are you saying? Well, yeah, I tried to tell you about the process, man. Dude, you didn't tell me anything about the child support. Lie after lie after lie after lie after lie. We brought you state witnesses. Anthony Hernandez. You heard her, the sister. She confirmed the relationship with Anthony. Even the name that he gave her at the beginning was his middle name. So that later on, if things got ugly, he was Anthony. He wasn't Ronald. He was Anthony. He challenged Reyes at the time, hey, take me to go see the sister. Why? Because they had never seen him. Aren't you gonna take me? Take me. Who's accusing me? Hey, dude, take me over there so that they could see me. He knew that they had never seen him. She confirmed the April 9th meeting. She owns a Mercedes-Benz. You heard from her how she lent it to her sister. And she also was the one that went to call Dr. Stern on April the 12th to say, Dr. Stern, please check my nephew. I don't think it was an insect bite. That's how it all started. Dr. Rodriguez, he had a working diagnosis. But one of the most important things that came out of Dr. Rodriguez's testimony was when I asked him, okay, now that the word syringes come out, would that change your diagnosis? He said, that would expand, was the word he used. I wrote it down. That would expand my working diagnosis. Meaning, so it would open it up to another diagnosis? Yeah. I don't remember what he called it. You all heard of it. I mean, it was a puncture, right? A pinpoint type lesion, I think he said. Pinpoint lesion. So you mean a puncture? Yeah, it was a puncture. But now we're introducing syringes into the formula. He's like, okay, well, I didn't know that then, but now if you're telling me they found syringes, maybe my working diagnosis would expand. I was going with what the ER had said and what the clinic had said. What was also significant about him was he said Dominic's condition never improved. His condition was actually getting worse. I wish that we would be able to find out what substance was put in him. And I wish that we could have found the weapon, and I wish we could have found the bloody clothes. But we have given you enough beyond a reasonable doubt to convict. Dr. Corinne Stern. Dr. Corinne Stern. You didn't hear from her once, you heard from her twice. She didn't perform the autopsy. But based on something that's rarely happened to her in her career, you heard her, right? She had a family member come over there and say, please check my nephew's leg. Now that he's dead, it all makes sense. Please check his leg. She goes, she cuts open the leg, she finds the black, dead, necrotic tissue deep in the tissue. And she calls it like she sees it, plain and simple. They want to say, well, you're in Alabama, you had all these other medical pathologists that turned on you and testified against you, and the DA dismissed your case. Hey, we're not in Alabama, we're in Texas. We do things differently in Texas. We need to send Alabama a message. But she's telling you the truth. Common sense. Common sense. Even today when I asked her, do you still stand by your opinion? I absolutely do. She never tried to make herself out as being some super medical pathologist and Nobel Prize winner. She just said, hey, I'm a medical examiner, and this is what I saw. You guys can believe it or not. That's what I saw. That's my opinion. You guys are the ones that decide. Adriana Flores, she's a criminal her friend. What was it with her? She said, I was the last one. How do I look? Wish me luck. How do I look? Wish me luck. The last one to see her alive. Bradley Dennison. This guy's I tell you what, an amazing agent for what he did that day. One of the most significant parts of his testimony was when he said, to me, it looked like an ambush. This guy's 17 years walking the brush in South Texas, cutting trails, looking for sign. And what did he tell you? There was a circle or a patch of grass where somebody was pressing the grass. Okay, let's go with that. Imagine you're about to kill your own son and the mother, and you're hiding in the grass, and you're getting ready to do this violent act. And you're waiting, and you're pacing, and you're getting yourself ready to do this. Now, I doubt he was just sitting there calm, being on tree. This guy was getting pumped up for the moment of truth. It was going to happen, and the grass was there. It was pressed down on the side of the trail. Nada. You heard him, the odd behavior that he saw. He takes the lead, and he sees all the contamination that his supervisor's doing. It doesn't make sense, but it makes sense later on. Elizabeth Stevens, Motorola, she places him, and you saw my co-counsel when he questioning her. She puts him right at the Border Patrol Station North, puts him on that trail through Motorola. Albert Cortez, he's the first officer on the scene. It's a bloody crime scene. He says Dominic looked like he was crazy, not thrown. Gilbert Benavides, remember his testimony.
Well, Gilbert, it's going to be the 20 that this morning, and he hasn't answered for the last 4 hours. He was supposed to be maybe Danny or the ex Anthony Burgos, who's a Border Patrol agent.
What did he tell Detective Ricardo Ramirez? I don't even know who the owner of the car is. I have lots of exes. you could extend me 5 minutes, please. I have lots of X's, he tells the detective. I don't even know who's in that car. Greg de la Cruz, he takes the belt. He takes the belt off of him, and it just falls in his hands. He catches it. He also takes the phone, puts him in the unit, and you remember what he says when he gets in the unit, right? Teléfonos. Andrew Masters, FBI certified. What was one of the main emphasis by FBI agent Masters? He used 5 independent sources to make his analysis. It wasn't one. There was a big there was a big emphasis put on, well, Sprint gives you this disclaimer. He was trying to explain, I just was not using Sprint by itself. I'm using a combination of different sources. Now, if a source on the antenna says that they're outside the Webb County Courthouse, okay, and then a camera from City Hall picks up the car there, well, then you can conclude that the signal was accurate. He put layer after layer after layer after layer after layer. And that's how we were able to put together for you that compilation. All the sources yielded the same results. And it places Burgos Aviles and Grizelda's phones at the crime scene, at his house, and all the important places. Adriana Escamilla, she's the investigator. She gets the camera from the drawbridge image. She gets the work schedule, the vehicle assignment, the certifications, and the child support letter at his desk. One of the most interesting courses that he took was on the weapons course. He was certified. Dealing with knives, you have it there. This guy was trained, he was skilled. Okay? There was only 2 units with that spotlight on duty that day. Kilo 66119 being driven by this man right here. Ronald Anthony Burgos Aviles, on the job, wearing his uniform, under the color of law, commits the double homicide. Nicole Morales, she establishes Burgos Aviles as a father. You have her DNA analysis. There it is. The stroller, Grizelda. The canopy, Grizelda. The headrest, Grizelda. The belt buckle, Grizelda. The belt keeper, Grizelda. The rock, Grizelda. The passenger door, Grizelda. The cricket phone, Grizelda. The rear passenger floorboard of the Kilo unit, Dominic. The cricket phone, Dominic. The ZTE phone, Dominic. The tailgate, Dominic. The science doesn't lie. The science doesn't lie. Detective Rick Reyes, Ronald. Remember, he gives him that incomplete name, trying to throw him off. Why? Because they know him as Anthony. It's like, dude, tell me your fucking name. That's because you didn't ask me. Web of lies. 27 stab wounds, Dr. Hernandez. The carotid and jugular are transected. Ladies and gentlemen, the person who did this, the individual that did this, had, what did he say? They had knowledge. They had knowledge on where and how to kill the person. You have the evidence. The 27 stab wounds to her head, her shoulders, her arms, her wrists, her hands, her back, her ear. All in the hands of this man. Supervisory Border Patrol Agent Ronald Anthony Burgos Aviles. What does he say? Targeted the vital areas with a sharp object. And what was most amazing of his testimony is that both mother and child were killed in the same fashion, transecting the jugular and the carotid arteries on the same side. You have it. He knew what he was doing and ending their lives. The detective, the investigator, he brought you the digital evidence, the video surveillance, Facebook, Snapchat, the timeline, the syringes. It's not a coincidence. Dr. Stern said, find some syringes in the lunchbox. Weeks later, syringes are found. They bring you evidence of him being on testosterone. That's fine. All it does is establish that he has access to syringes. What did he put in that child on March the 25th? Intent. Knowingly. Trying to end him.
Hey, he's the guy that found the body. He's the border patrol agent that found the body. Does anybody have visual on him?
What's missing? The murder weapon, the bloody clothes, and the 5 minutes by the church. Everything under his control. The murder weapon, the bloody clothes, and the 5 minutes by the church. There he is, calculating, manipulative, and deceptive, hiding behind the badge. Lucky they are. Think about that. What were the last words that Adriana said to Grizelda, or what Grizelda said to Adriana? Wish me luck. How do I look? Wish me luck. And then the little baby is wearing a shirt, a baby Yoda, and it says, lucky I am. And I'll tell you what, the luck wasn't with him on that day. It wasn't with him on that day. But the luck is with him now. The luck is with him now because they have you. They have you. He's guilty. The only thing left for you to do is go in there. Find him. Guilty on both counts. Find him guilty.
You may proceed.
Now listen to this mess, because this is what his closing statement is, a mess.
The best in the world, but only if we apply the legal principles upon which it is based, only then will it function properly. I never imagined that I would hear Mr. Hernandez telling the only thing left to do was to go into the jury room and find him guilty without deliberating, without looking at the evidence. That's not how our system works, ladies and gentlemen. I understand, I get it. We have a dead mother, we have a dead child, and it's a type of case that elicits very strong emotions. But that's exactly why we have to adhere to the legal principles that are the foundation of our criminal justice system. Because that system is designed to minimize, not to completely remove the possibility of an innocent person being convicted, but to minimize the odds of that happening. And so when you make an argument that is based on anger, on emotion, on displaying bloody clothes that proof that somebody was murdered, but they don't tell you the thing about who committed the murder. What is the approach? The approach is to elicit the mentality of a lynch mob. And that's the last thing that we need in a case in which the state is seeking death against the defendant. The most important principle that you can take with you into the jury room is to deliberate with wisdom, with fairness, with extreme caution, and with the emotion for what you've done with your duty. If I can have slide number 2. First, we begin with a legal proposition that all persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. And that's the very basic principle of our legal system. The defendant is not required to prove his innocence. The state has to prove it. But they have to do it with rational, persuasive evidence, not by wrenching emotions that want you, the jury, to just get vengeance or revengeance. That's not how it's supposed to work. Slide number 3. The right to a presumption of innocence is so vital to our criminal justice system that it's embodied in state law and in federal law. In state law, you find it in Article 3803 of the Code of Criminal Procedure. And then it's also embodied in the Due Process Clause of the 14th Amendment to the United States Constitution, which guarantees all persons a right to the presumption of innocence. The presumption of innocence is not specifically set forth in the Constitution, but the U.S. Supreme Court has long held that it is a very essential component of our criminal justice system. So you have to begin with that presumption that Mr. Burgos is innocent. You remember during jury selection, Mr. Hernandez and his assistants constantly ask you whether you could set aside your bias and your prejudice and render a decision, a verdict based on the law and the evidence. Well, now they simply have forgotten that. Now they want a verdict based on bias and prejudice. And that's what you have to set aside. And take a look at the evidence. This is largely, almost entirely, a circumstantial evidence case. And although circumstantial evidence may carry as much weight as direct evidence,
Circumstantial.
the pieces have to fit together to be able to actually arrive at a verdict of guilt. slide number 4. The burden of proof is always on the state, and the defendant is never required to present any witnesses or evidence. If the state fails to prove its case beyond a reasonable doubt, it's the duty of the jury to find the defendant not guilty and to acquit him. And reasonable doubt, I will remind you, is the highest level of proof that we have under our criminal justice system. The state has shown you during voir dire that the state does not have to prove its case beyond all doubt, and that's true. I'd like to give you some legal standards of proof that also are not what is meant by beyond a reasonable doubt. Slide number 6 shows you that a reasonable suspicion is not proof beyond a reasonable doubt. A reasonable suspicion is a very low level of proof. It's the level of proof that an officer needs to have to conduct a brief investigatory stop. And then we also have probable cause. And probable cause is another level of proof higher than a reasonable suspicion, but it still does not rise to the level of proof beyond a reasonable doubt. A probable cause is the level of proof required to issue a search warrant or an arrest warrant. So if the higher standard of proof than reasonable suspicion, it's well below the level of proof beyond a reasonable doubt. And then we have the preponderance of the evidence, which is the standard used in civil cases. And in civil cases, people are usually fighting over property or money, and so it doesn't require as much proof as our system requires to deprive a person of his life or his liberty, which is what we have in this case. Proof beyond a reasonable doubt is the high standard of proof in the American legal system because the law does not contemplate that it should be easy for the government or the state to deprive a person of his life or his liberty. So that is the standard by which you must decide the fate of Mr. Burgos Aviles. Has the state put its case beyond a reasonable doubt? A person who is accused of a crime has an absolute right, slide number 7, has an absolute right to either testify or remain silent. And if he decides not to testify, no inference of guilt may be made from that decision. It's an absolute right to either testify or not testify. There may be many reasons why a person may choose not to testify. He may feel that the state simply didn't present sufficient evidence to prove the case against him. He may have a speech impediment. He may just not be a good speaker. And so the law, in its wisdom, has decreed that a person has that absolute right to remain silent. And it's something that you have to respect. Don't question why Mr. Burgos made that decision. It's his decision alone, and it should be completely disregarded in deliberating on his guilt or his innocence. Now, slide number 8. The state's case is based primarily on circumstantial evidence. So it's important that you understand the difference between direct evidence and circumstantial evidence. Direct evidence is evidence that directly points to the defendant as the one who committed the crime. For example, on witness testimony, somebody comes in here and says, I saw X shoot Y. And I'm sure people said, I've known him for a long time, I can possibly identify him, and I saw him shoot. That's direct evidence. A confession by the defendant is also direct evidence. Circumstantial evidence, on the other hand, is evidence from which the jury can reasonably reach an inference that points to the guilt of the defendant. And although the jury can make reasonable inferences from the evidence, they are not allowed to speculate. A reasonable inference is a conclusion based on known facts, whereas speculation requires guessing what the facts are. Slide number 11. For example, Detective Richard Reyes testified that Mr. Burgos became a suspect because he failed to give investigators his full name and only identified himself as Ronald Burgos. But everybody at Border Patrol knew him as Ronald Burgos. His name tag only said Ronald Burgos. And then Detective Grizelda Garcia was the last one to testify, admitted that when he first arrived at the scene of the crime, he saw 3 Border Patrol agents there. It was Bradley Davison, Burgos and Francisco Lara. And the first one that he spoke to was the agent who reported finding the body, which was Mr. Burgos. And he asked him to identify himself. And Mr. Burgos had to take his ID, which showed his complete name. Ronald Anthony Burgos Aviles. And so the customer quickly jumped to the conclusion, he didn't tell us Ronald Anthony Burgos Aviles is his name, and therefore he's guilty. Put the rest of the car and take it out off and away they take him. And so this is the type of circumstantial evidence that we can take the reasonable inference on, because the evidence itself may not be true. Before you reach the reasonable inference from a piece of circumstantial evidence, we have to find beyond a reasonable doubt that the circumstantial evidence itself is true. If it's not true, we can't project a reasonable inference from evidence that is not true. And that's a final example right there. Slide 13. Experimental claims that Ronald was intentionally contaminating the crime scene. The Border Patrol agent Lara, while accusing Mr. Burgos of contaminating the crime scene, was himself contaminating the crime scene. Remember, he got a pair of gloves from the nation that he was trading, Smith, is what I recall his last name was. He got one pair of gloves, so he put one on to give the other one to Mr. Burgos. And he touched Grizelda's body, checking for the pulse, the same thing as Mr. Burgos did. And then he threw the blood glove on the tree again. And then realized, I'm contaminating the crime scene. So what does he do? He picks it up, and instead of placing it in a plastic bag or receptacle where he can deliver it to the cops without further contaminating it, he throws it in Mr. Burgos' pickup truck, his abandoned truck. Now, there's also blood on the side of the truck. I imagine he occurred the same way. Maybe there's a Lara or somebody else. There was a lot of stuff wrong, nothing in the area. It was chaotic, and Border Patrol agents there were being engaged. There was a helicopter hovering overhead, probably with a spraying flecks of dirt all over the place. If anybody opened the door to Mr. Burgos' vehicle when the helicopter was overhead, it could have basically blown some flecks of dirt with blood on the Mr. Burgos' vehicle. Slide number 14. The state also relies on GPS-like data that was extracted from Mr. Burgos' government-issued mobile phone. But the state's expert testified in the cross-examination that she only measured degrees of magnitude and the longitude. She did not include hour or minute measurements, which are intended to produce a more precise location. It's not like reading a clock. If I just read the hour hand, I won't tell you it's 9 o'clock. If I read the minute hand, I can tell you it's 9 o'clock with 50 minutes. And if I read the second hand, I can be even more precise. I can tell you it's 9:15 with 20 seconds, 9:15 and 20 seconds. But she only took latitude and longitude. And so I asked her if 1 degree of latitude equals 69 miles, and 1 degree of longitude equals 54.6 miles. And she said she agreed. That was all that she did. So what does that do? Well, those are very broad measurements that placed Mr. Burgos within 69 miles for the crime scene, within an area that he was assigned to patrol that morning. Slide number 15. The state also points to the example that the cell phone has been found in Mr. Burgos' patrol unit. So Mr. Burgos told the investigators at the scene that he had picked up the cell phone. And just as Mr. Burgos handed his ID to investigator Garcia, and then later the investigators twisted it around to say, hey, you didn't tell us your full name, so you're guilty, get in the car. Same thing, they forgot that investigator Garcia had it, and then he gave it back to Mr. Burgos. Mr. Burgos forgot that he had gotten it back because he was in shock. Several of the state's witnesses says that he looked spaced out. He looked like he was in shock. Yeah, because he had just witnessed a horrible crime. Maybe he was going to meet with Grizelda at that moment. But can you really conclude from that that you killed her? That's a huge jump in logic to make.
What the heck is he talking about?
Punctual one. They want you to take the word of Florence Stern, who had a woman on death row because she diagnosed the death of that woman's baby with suffocation or strangulation.
I'm sorry, Mr. Peña, I'm just gonna object to that. There's no evidence of anybody being on death row. Those are facts, not evidence.
I really might ask Dr. Stern about that.
I was trying to jury that you are the first fact you do your best effort to follow the testimony of the witnesses that have been brought here, and testimony has been admitted into evidence. Do your best to recall that. Remember that I instruct you that whatever it is that the lawyers tell you was the evidence is not the evidence, unless in fact you heard it actually come from the evidence. So you use your best recollection to do the same. Thank you.
Dr. Stern also thinks that she's board certified, and she's not. She came back and muddied up the waters and more, and that's the type of witness that's achieved. But they want you to disregard the emergency care clinic, which diagnosed the punctual wound as an insect bite. They want you to disregard Dr. Antonio Rodriguez, the pediatrician who saw the child 3 times, and each time diagnosed the wound as an insect bite and prescribed previously an insect bite. And the state wants you to disregard the medical records from the doctor's hospital, which also show that the diagnosis was that it was an insect bite. And then there was a testimony of Adriana Flores, who also testified that Dominic was already sick the night before he sent the med with Ronald at Wayfield Park. So, above all, ladies and gentlemen, remember to rely on logic, reason, and cool reflection, and set aside the lynch mentality that the state wants you to go into the jury room and deliberate. That's my place to do. Thank you.
He said a whole lot of nothing. A whole lot of stuff that's not true.
Ladies and gentlemen, we do not promote the lynch mob mentality. Everything that we brought you, all of the evidence, the physical evidence, the direct evidence, the forensic evidence, the circumstantial evidence, the medical evidence, it's all credible, it's all consistent, and it's all corroborated. You make your decision individually, collectively, and I agree with Mr. Peña. This is a serious matter. This is a serious matter. But when you go in there, let them guide you. Let Grizelda and Dominic guide you. So that you can have clarity and you can be able to be confident. And I guarantee you that when you take all of the evidence, all of the physical evidence, everything that we brought you over these last 7 days, that you'll be able to go home tonight and have a clear conscience that you did your job, that you weighed all the evidence, and most importantly, that you brought justice. That you brought justice to baby Dominic and to yourself.
Thank you, James. Ladies and the jury, I'm now about to send you into the jury room, which will become your jury deliberation room. Will you follow the instructions I've given you in the charge and start deliberating? So we will have the 4 alternates step out to another room. You will not be in the same deliberation room. You will be in another room, waiting to see if, in fact, your services will be needed. Thank you.
All right, so this is Let me go out here and see. So yeah, he did have to give a defense, but I think like, you know, trying to add extra stuff that was not like proven in this case. And I think it was distasteful for him to still take jabs at the medical examiner when she came there and explain what she meant. It's just yeah, I understand that he wanted to be a good defense attorney, but they did give them a good defense, but you know, muddying the water, they didn't need to do that. Like, you know, this medical examiner, it's a slap in the face for her to be a medical examiner as long as she has been a medical examiner, writing peer reviews for you know, for forensics and, you know, everything that she does every day. And for them to, one, try to wait till she was gone to try to get her testimony struck from the record because she went against what everybody else says. But the other doctor said that if they had that information about a possible syringe being involved, they would have not said that it was an insect bite. But that's what they were thinking. That's what Grizelda was thinking at the beginning, that it was an insect bite because she took him to the park or whatever. And the only way that they were able to know that something else was amiss and this just wasn't right was, thank goodness that her sister is a nurse, and that when she looked at the wound and it was bleeding, that the blood was black. So she knew that something wasn't, you know, right. But at the time, they just went with he was possibly bit by a spider or whatever type of bite they thought it was. So yeah, I just think that they just did that whole thing in court where they had this medical examiner come back and testify again. And I just think that for him to try to use that on cross and try to throw in her face, because she moved to Alabama, worked as a medical examiner there. She made a ruling. I mean, not a ruling. She gave her expertise on what she thought about the baby passing away. Some other people didn't. Well, other people didn't believe her. So you have people that are there, you know, strictly for the defense, and people that are there strictly for the plaintiff. But so, of course, they're going to have their experts come and testify, and then, you know, the state has their experts come and testify. So she still stands by her, you know, what she said in that other case. She sued them on top of that, because she said there was a lot of stuff going on there. And she decided to come back where, you know, to Texas, where she likes it. She says she didn't like it when she moved to Alabama. She didn't like it. I guarantee you there was some corrupt stuff going on. That's why she said what she said. I just believe that. But yeah, I just feel like, and I understand they have a job to do. They're trying to defend this loser to the best of their ability. But I think to just like try to attack like the medical examiner the way they did, I thought it was done in poor taste. And yeah, it shouldn't have been. I mean, I don't know what you know, their thoughts were. So you know what? So this is going, let me see. Hold on, because he is at the end here. We're at the end here, but the judge is back on the stand. So let me just play this because it'll finish out. I saw him at the end. This day and then tomorrow. I saw him at the end here. Oh my goodness, I cannot take that name lower. Attorney Greasy. Oh my goodness. He make me sick of that attorney, the way he... Okay, here he is.
It's July 6th. It's signed by
Hold on, because he's back. And it's right at the end. So hard to get it. All right, there he is. Let's go right here. Okay. All right, he's coming on right after this. I just can't get it like direct, but he's coming on to say something to Judge. It should pop up any second. He did. He was a mess. Yeah, he was a mess during the trial. The older man. You know, I don't talk about him because he passed away. So I don't want to say too. No.
Now with you all because it won't take much decision on y'all's part in any event. So I know that Mr. Anís is not here, but there are other assistant DAs here that can listen to this. And like, if the defendant's out in the courtroom with his president, the defense team's here. We got a note early on. It's July 6th. It's signed by, I'm assuming, if they followed our instructions, the presiding juror, foreperson, last name. We would like to return tomorrow and start fresh. Would that be possible? Please advise. So, obviously, they just started deliberating. So, my inclination is just to tell them to continue deliberating in my standard sort of form. I don't really want to say, give me, what the law is type of thing yet. I don't think I need to. I'm also just wondering, on, I think 3532, in anticipation of further similar requests. Is it 22 or 32? No, maybe not. $36. All right, anyway, the rule, as you know it, is, as I know it, is that on either the court's motion or any other person's motion on a felony case, once the charge has been read and they start deliberating them, they cannot be separated. In that case, I would think that needs even more so. So, anyway.
Just for the court's knowledge, there was an order a while back in 2023.
I think we already addressed. There was a motion already filed, so there is no separation. Either party could file the motion, and it shall not be separated upon motion. I think I've already signed the order. In any event, that's not where we are now. I'm not, unless you want me to advise them that. But.
No, sir. We have no objection to them going home, separating, and returning tomorrow. Judge, I believe the court said it's very early. It doesn't seem like the deliberations have really started even. So.
Well, but the problem is that there's already 2019.
Yes, sir. And it was, if I'm not mistaken.
It was filed by the defense, was it not?
Yes, I do believe it was agreed and signed by this court. It was just a question of the jury hearing.
No, I'll look for it.
Judge, we would
Oh, you did? Fair enough.
Oh, what happened? Did it just end like that? Hold on, because yeah, it was at the end. But I didn't think that it ended like that.
And the only one that have been deliberating has been the 12 jurors. So the other 4 individuals, alternates have been in a separate room.
I thought that they went home, but maybe not, because this is it rolled over into the next. So I think he has the verdict here. This is a very short video. I think they decided in 4 hours, or I think maybe a little less than 4 hours. but I know that, you know, they have a rebuttal case after this. So we'll watch that. I'll start that tomorrow for his sentencing, because it's like a whole, some courts do it with, you know, they have a rebuttal case, and it's just like a whole, to me it seems like a whole mini trial. And some places don't have that, like the rebuttal case, but this case
the jury,
does.
I understand from the communications with the bailiff that you have reached a verdict.
Mhm.
Will the foreperson please stand? Good evening. Thank you. You were selected as the foreperson by the 12 or the 11 other members of this jury, 12 including yourself. Is that correct? Were the deliberations done in accordance with my instructions? Was there a unanimous verdict that was reached? Was the verdict form attached to the charge of the court signed by you in accordance with the unanimous verdict? Please hand the charge and the verdict form to the bailiff. Thank you very much for your service. You may have a seat. Madam Foreperson, please stand again. One more question. Was the deliberation in the deliberation room done only by the 12 jurors, and were they the only ones that were in the jury room? The alternate jurors were not in the jury room, is that correct?
Yes.
Right, thank you. All right, this is the verdict in case number 2018 CRA 852D1, the state of Texas. If you could care to stand, Mr. Ronald Anthony Burgos Aviles. Verdict of the jury, count one. We, the jury, unanimously find beyond reasonable doubt the defendant Ronald Anthony Burgos Aviles guilty of the offense of capital murder as alleged in count one of the indictment, signed by the foreperson.
Yeah, Lord.
Verdict of the jury, count two. We, the jury, unanimously find beyond reasonable doubt the defendant Ronald Anthony Burgos Aviles guilty of the offense of capital murder as alleged in count two of the indictment, signed by the foreperson. Thank you. You may be seated. Mr. Vega, do you want me to poll the jury? Thank you. Members of the jury and alternates, we are come to the conclusion of phase one of the trial. We told you that there would be two phases of this trial. We will start with phase two of the trial tomorrow. It is 10 o'clock. I'd like to be able to get started tomorrow. We will be getting started tomorrow with the guilt phase of the trial. Because of the lateness, I guess, of today, I will start a little bit later. I know you may be tired.
Guilt phase, yeah.
But we're not going to be done tomorrow with the phase two of the trial. We're going to start it tomorrow. So we will start again with opening statements. And then the presentation of evidence will begin right after that. So I'm trying to see, because you've worked late today, whether or not you are fine coming in 10 o'clock in the morning tomorrow, perhaps, give you a little bit of time. So let's say we get here right before 9:45 or so, and 9:30, and get ready to start at that time. So we can start as soon as everybody's together. So hopefully we get started no later than 10 a.m. Again, it will only be the start of phase two of the trial. We suspect that will take equal amount of time or more than we've taken in this case, in the first phase. So alternates, you continue to be alternates because we have so much more time left. I need to keep you here. So I hope that you understand. Tomorrow, the alternates will sit the way you're sitting now, and will continue to go in the way you would normally go in before with the entire jury. It is only during deliberation, in fact, you are separated if you're not an actual jury. All right, so I think we can separate now. You have your juror badges. Same thing. The sheriff's office will have the same instructions with regard to where you park. Everything is the same. We just start the first phase of the trial a little bit later on because of the lateness of today. And tomorrow you'll receive the opening statements and perhaps some instructions with regard to what to expect moving forward. Other than that, have a good evening. Give me 1 second. Well, the case is the entire case is not over. I continue to admonish you that about everything, all the other rules that still apply. You're not released from those instructions. If you need, again, to refresh your memory on it, please review them before you go home, or take them with you and review them while you're home. We're done with phase one of the trial and not the entire trial. Please remember. And I admonish you to please adhere to those rules. Thank you. You are excused for the evening. Have a good evening.
Okay, so that's it. He's found guilty. So tomorrow I'll schedule a live to start the guilt phase. All right. So yeah, so tomorrow I'll schedule a live to start the guilt phase. It's going to be earlier than today because I'm just going to use this computer. I'm not going to try to use the new one that's not working. So I'll schedule the live for tomorrow. Thank you all that tuned in to watch. This case is one of my favorite cases. So I'm going to end it here, and you guys know it wouldn't be me if I didn't tell you to get your mammograms, fill your boobies to make sure you are all right. All right. And don't you dare let anybody come into your house and disturb the peace that passes all understanding. I am Survivor Speaks, and I'll see you in the next live or video upload. Peace.
Full cycle, I just might though, just like a Michael. Mama gone now, I'm thinking death is now we entitled. And it was me versus me, them battles had to fight through. And when you way in the dark, them demons try to fight you. But you can't let them when you gotta see the damn light. Diabetes came from nowhere, messed up whole life. That's what I used to think, my mama helped me out. I got one dairy in this guy to make proud, don't count me out. Let's get it started, rest in peace my mama, I don't wanna talk. Fresh fit, who that little nigga, fresh the way he walk. New drip, I'm that one